Your Lordship. I beg to mention item number 42 and 43. In this case, my lord, petitioner instructed me to withdraw this petition. But
Item number?
42 and 43 orders, my lord. I am instructed to withdraw verbally. My lord, that no consent letter has been given to me. Can it be taken up on Monday so that we can get the consent letter? Because it's,
Matter pertains to?
my lord, this sanction letter has been issued and we have challenged this sanction letter, prosecution sanction letter issued against me. And that sanction letter has been challenged. Mr. Lord.
Then what have you got? You got an interim order?
Yes, yes. Interim order is there. That is
Now why you want to withdraw?
that I don't know, my lord. I suggested them to do the case, but I don't know what happened to them. Already the person retired. That may not be, my lord, the reason.
You are in no with this particular, you are in connection with this, have any telephonic connection with these two persons, the petitioners?
Petitioner number, in one petition, I have the contact. My lord.
Inquire with him. We'll take it up at 2.
My lord, can it be on Monday, my lord?
No, nothing doing on Monday. These are 2014 matters. There's a stay.
Yes, yes, that is.
No,
Tomorrow can be, my lord. More separate.
we'll see at 2.
My.
We'll see when the matter is taken up. 2014 matters, I'm not adjourning. Sorry.
Hey, please, Your Lordship. Lordship, I beg to mention item number 12, Lordship. Lordship, this matter may be withdrawn, Lordship. Because
Huh?
my lord, this matter may be withdrawn. My lord, there is a matter subsequent development. My lord,
You want to withdraw
yes, Lord. With a liberty.
the
Lord.
council? What liberty?
My lord, there is a subsequent development.
Huh?
There is a subsequent
We'll
development.
take it up when the matter is called then. For liberty, I have to hear the other side.
Yes, my lord, then no, my lord, without liberty.
The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. In that view of the matter, the instant writ petition stands closed on withdrawal.
Oblige, Lordship.
Item 12, no?
Lordship.
Made to your lordship. Would you consider back to mention item number 7 and 8, your lordship? In this matter, I am led by senior counsel Mr. N.C. Das is not well since yesterday afternoon. I need to accompany him to the doctor, your lordship. Can I seek accommodation for today, your lordship? Hey, Mr. Das is not well, your lordship. I need to accompany him to the doctor, your lordship.
Senior counsel?
Yes, your lordship.
Senior counsel, I don't give adjournments for it.
I need to accompany him in doctor.
You do it.
Can
Next.
for accommodation
No,
today, your lordship.
we'll see when the matter is called.
Oblige, your lordship.
Your Lordship, I beg to mention item number 37 on behalf of B. Sinha, my lord. He was suffering from high
Item
blood
number?
pressure. 37.
37. Okay. You want an adjournment?
Yes, my lord.
When?
After 2 weeks, my lord.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
May I please, Your Lordship?
Mm.
I beg to mention item number 21, Lordship. I pray for adjournment. The engaged counsel is not well, so he could not appear today.
You are for the petitioner?
Yes, Lord.
At the request of the petitioner, learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Next. I beg to mention number 39 from the daily list. Kindly give us
30?
39. Kindly give
39. 39. Yes.
For affidavit in opposition. Filing for affidavit in opposition in need some time.
You are filing for?
Affidavit in opposition.
You are appearing for the respondent?
Respondent number 6.
You have taken the consent of the other side? The learned counsel appearing on behalf of the respondent number 6 for an accommodation. List the matter after 6 weeks.
May it please your lordship. My lord, I pray for withdrawal of item number 54. Lord. Actually, there is an inadvertent error of not implementing the necessary respondent in the writ petition, your lordship. An IA was filed for correction. Separate IA was filed for correction of the writ petition, where some corrections were required. In that IA, we could not add that necessary requirements for So on last occasion, when the matter came up before this honorable.
So you want to withdraw the
Ye- ye-
petition with
yes.
the liberty to refile?
Yes, yes, your lord.
What is the reason why you want to refile or you want to impede somebody?
Yes, because already IA is filed for this one, what do you call it, correction of the writ petition. The second IA, I don't know whether it's allowable.
What's your name?
My name is N. Arzari, your lordship.
The learned counsel appearing on behalf of the petitioner submits that there are certain formal defects in the writ petition. And as such, he wants to withdraw the instant writ petition with the liberty to refile. Taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is granted to the petitioner to refile with by removing the formal defects.
Highly obliged, your lord.
May I please, Your Lordship? I beg to mention for item number 30 and 31, Lordship. Matter may be adjourned for today, Lordship. My senior is out of town, Lordship.
What?
30 and 31, Lordship. We have taken consent from the other side, Lordship.
What is the matter about?
Lordship, it's a non-payment of ad valorem levy tax, Lordship.
Then you gotta stay.
Lordship.
You're vacating the stay. Then you take how much adjournment you want, you take it.
Lordship, matter may come up on Monday, Lordship.
No, you do it. You want an extension of the stay. You don't want an extension, no problem.
Only accommodation for today, Lordship.
We'll take it up when the matter you do it. I'll help you out. Yes, next. Chalo.
Release item number 1 for motion.
My lord, kindly for the timing, lord. I am not the engaged counsel, lord. If it's a BJ Ghosh.
Yes, Mr. Chaudhary, what is his matter?
For the land. With the name of her. That's where it was mentioned. Therefore, the policy to get it. And the initially on her place, the application, it I must refer it to one. To one means person and on that for long. So after the contact was selected in fact, after that the contact in the name of the father of the husband expert of that time. And therefore at that point of time, the last time that it didn't have the time.
The land belonged to the husband. And the husband died. But didn't the land devolve upon her?
But at that point of time, it's not in her name, or there was no law, therefore, take her as a.
Does the guidelines stipulate that it has to be mutated or has to be the ownership?
My lord, I think it's the guideline.
Yes.
I think the expert would be about become. Good file.
Yes.
Land applicable to all. Yes, Roman file. Yes, it has to be classified as action below based on the land offered or the land not offered by the applicant. On applicant has to pick of land, the applicant either by a long term for a period of minimum or as applicant by the applicant that is found for a period of land for purchase of long term for a period of 19 years. Three applicant enter, madam, group three. And madam, in the event that the selection one and two, that's about it.
But if the land belonged to her husband, by the law of inheritance, automatically wouldn't it devolve upon her? Where is it? For the purpose of family member would comprise of cell spouse also. So the spouse land would be his land itself if it is. Whether mutation is the consideration, where is it mentioned that it has to be mutated?
And my God, if it is a family land, then no, he did not also accept the certificate, take the time to.
Is it their mandate out here to bring the legal hair certificate?
Mandate is that you have to have your own land for a long-term.
So wouldn't the moment, if the, I would have understood, the land otherwise belonged to the husband out there and she had given it without taking the no objection from her husband during the lifetime of the husband. But if the husband had died earlier and she becomes the wife, she is the wife, wouldn't the land on the basis of the immediate death of the husband devolve upon her? If it is legal heirs, but is it mentioned that if there are other legal heirs, then you have to give this thing?
That extent about the letters are signed, but if you refer where the land will be considered that is actually all that does not.
But she has offered the land.
That right. That's
Because in her applications form, she has stated that her husband has died. Kindly see at the serial number 13, page 13. Name of the owner of the land, leaseholder, relationship with the applicant, date of registration. See, name has been given of the husband. Then spouse, registration obtained in 3-4, so and so, patta number so and so.
When the application, at that point of time, that was not her name. It is his husband's name, they are declared, and he does not modify the home of the other.
Did you ask them? Because otherwise it is not required as per the year for filing a no objection from the other side, from the legal heirs. How? Because she has offered a land. Group 3 will be applicants who have not offered land. But she has offered a land. Then here it says applicants have suitable piece of land in the advertised location. Wouldn't that be construed to be a land in her location? Where does it say that it has to be in her name? Either by way of ownership. Ownership she has got because it has automatically devolved upon her immediately upon the death. The devolution is automatic. Mr. Chaudhary, devolution of a property of the husband, the moment he takes the last breath, it is automatic upon. Huh? Children may be there. There is no, but the devolution has happened unless there is a probate. There's a probate to the there's a probate or a gift made out there. That is a different thing. But the otherwise, that is aspect of matter you have not taken into consideration. You have taken him as a group 3. Now what has happened? You have allotted to somebody.
But, the last, I don't. Wait.
Hello?
The little-
When can you do it? We'll issue notice and don't do anything in pursuance to this.
So that's why.
Issue notice. Making it, when do you want it? We'll dispose it of. It's a short matter. There's anybody else?
They might not have the format for it.
Your entry. Issue notice, making it returnable on, let's have it on 17th. We can dispose it of on that. Issue notice, making it returnable on 17th of August 2023. Mr. M.K. Chaudhary, the senior counsel, appears on behalf of the respondent number 2 and 3. Extra copies of the writ petition be served upon Mr. A. Bopper Kotoki, the learned counsel assisting Mr. M.K. Chaudhary. Who appears for respondent number 3? 1. Union of India, anywhere? Have you seen any Union of India counsel in today? Welcoming S.S. Roy, R.K. Dev Chaudhary.
Yeah.
Huh?
We'd ask the report to one. Must I agree?
None appears on behalf of the Union of India on call. The petitioner is given the liberty to serve a copy of the instant writ petition upon Mr. R.K. Dev Chaudhary, the learned Deputy Solicitor General of India. The petitioner herein is aggrieved by the action of the respondent authorities in placing the petitioner in Group 3. Of clause 4, Roman 5. In respect to the land offered by the petitioner. It is the specific case of the petitioner that the husband of the petitioner expired prior to the filing of the application, and the land belonged to the husband of the petitioner. The land belonged to the husband of the petitioner, and upon his death, the said land devolved upon the petitioner. Taking into account the issue being, taking into account the issue involved, and there being also an urgency shown, shown, this court is of the opinion that the matter requires an urgent disposal, for which the matter is fixed on the return for which the matter on the returnable date an attempt shall be made to dispose of the petition. In the interim, this court further observes that status quo be maintained in respect to the retail outlet dealership at Bilasipara town, bracket, from Beltoli to Bongalipara in the district of Dhubri.
Item number 2.
Yes, what is it?
Let's take settlement of land. For us,
Then you don't want to.
want to, my lord, the concluded process of 1960. They have approved for earlier.
Huh? Yes,
Item two, my lord. May I please, your lordship? My lord, matter relates to my lord eviction. Matter relates to my lord eviction, my lord, of some farmers and villagers, my lord. On last question, my lord, I apprise honorable court for enabling a document under RTI, my lord. That was subsequently received, my lord. And unfortunately, my lord, it was not produced before this court, my lord. So, my lord, that was vital document I have with me, my lord, right now. So I want to submit this document by one affidavit, my lord. And that was very vital document. I have with me right now. Regarding it was given by circle officer,
Mr. Counsel,
my lord,
you filed a writ petition in the year 2021,
my lord,
eviction against an eviction
my lord.
proceeding.
Mile.
There is no stay.
No,
No notice has been
Yes,
issued.
yes, my lord, right.
You knowing it very well, 2 years you have not brought in any documents.
This was my lord received.
Why do you want that document?
Uh,
What document do you want? This is a forest land.
No, my lord. My lord, I will correct your lordship, my lord.
Ah.
Most humbly, my lord. There are several notifications and ordered by the erstwhile government, my lord, that this particular forest land has been reserved, my lord.
Where is the document?
Yes,
Show me.
your lordship. Says, well, I come hurry from another court, my lord. Your lordship may kindly produce type copy, this one, page 20, connector B, my lord. Since, my lord, it was a document of 67, my lord. The vernacular is at page 21, my lord.
I
May-
am directed to say that the government of Assam is pleased to accept the proposal for de-reservation of 15,000 bighas of land in Derapata area of the river in Nagaon district. In lieu of so and so, USF demand in so and so, which is being made in a new forest reserve. On de-reservation, 10,000 bighas will be handed over to the Relief and Rehabilitation Department for settlement of the refusee and 5,000 to the settlement for settlement of landless people according to the project.
Thereafter, my lord, several such, my lord, notification issued, and my lord, a case was filed in the year, my lord.
So you are landless.
Yes, my lord. I come in the category of 2,000 and 3,000 bigha. That was, my lord, now in that particular document that I have now, it was clearly said that this 2,000 and 3,000, not 15,000, not 10,000, my lord. 2,000, 3,000 bigha is a gaon, is a village. Now, my lord, this is a part of the process of settlement, my lord, for landless people, my lord. That is, my lord, so my limited knowledge is concerned, my lord. That's why, my lord, I am trying to produce this RTI document given me later. And these are, my lord, purely they are uneducated farmers, villagers. Somehow I could able to get this document, which clearly said that there are no village like 10,000 bigha in Kaki, but 2,000 and 3,000, these are village. And this is a part of, my lord, subsequent deforestation, de-reservation. Then, my lord, it was also a notification which said that 2,000 and 3,000 may be given as a settlement to these landless people. That is the, my lord, in a nutshell, this case, my lord. Your
You
lordship,
say
I
that
kindly-
these are forest village.
My lord, before 67,
Are you saying that these are forest village?
forest,
Forest village.
my lord, could not able to.
Have you looked into the forest, Assam forest regulation?
Today,
And there is also another act. What is that?
Forest conservation.
Forest conservation. And there is another one now. Huh? Ah.
Definition of forest rights.
Forest rights act. Have you looked into those?
my lord, to be honestly, my lord, I have not gone through it. But, my lord, there was a some another circular
might be notification. I am, my lord, pointing out. It was, this point is raised, my lord, that since my lord Honorable Guwahati High Court at that, in that case, it was a case number, page number, my lord, page number 30 onward, my lord, Annexure G.
Now, what are you asking for in your writ petition? You want settlement?
My lord, at that period of time, my lord, the eviction drive was, my lord, conducted in two parts at that point of time. So we issued the stay of this notice that was issued to us, and that very much notice was, my lord, undated notice, my lord. Your lordship can peruse this notice at page
15?
14, 15, my lord. It was done, but the said particular release notice was undated. Page 15 onward. 14, 15, 16. And it was Mati topsoil given below, that is 3000 biga. This 3000 biga now, the document which has given to me.
Now, did you apply for settlement?
Yes.
Where is that?
We have submitted some affidavit.
Where is that? You have applied for settlement? Page 26.
My lord.
Okay.
Yes, it's my. Yes, my lord. These are the predecessor of the petitioner. They filed case before this honorable court, and by way of an affidavit, they said that we are, as a part of the de-reservation of the forest, we have been assured by the government that we have been settled down. Those parts regarding 2000 and 3000 biga, not 10,000, my lord.
But these are all 2000 biga.
Yes.
But you
2000,
come under your village, your address is 3000 bighas.
this is as per this, as per the order of this court. At that
Where is your
point-
application?
My lord, the very notice itself, the notice came to me, my lord. And the address which was shown below this notice is 3000 biga.
No,
Page 15,
Mr. Counsel, I can only protect you provided you have some application.
my lord, correctly.
Where is that application?
My lord, so far as this case is concerned, my lord, it is admitted that it was earlier forest land. Subsequently, it was de-reserved. And
So the moment it is de-reserved, it becomes a government land.
yes, my lord.
Now, therefore, they have initiated action under 18.3.
Before that, my lord. it is-
Now, the question therefore is,
My lord.
if you have a settlement or you have applied for settlement of the land, this court can protect you. But where is it?
My lord, so far as my knowledge is concerned, when this process is carried out on the field, we have submitted some affidavit, my lord.
Where?
And that was a part of this case, my lord. I have annexed in this case, my lord.
Where is it?
Page number, my lord, 26. 26, page 26,
26.
my lord. In this case, my lord, we have submitted our detailed affidavit.
But this is for the 2000 bighas of land. And how do we know that this is being done? Now, how do we know that it is yours?
Settlement given to some other petitioners, other persons.
Understood. That is what I'm saying. This is for all these are 2000 bighas, not the 3000 one.
My lord, if you will for a moment come to page,
That is why you have no worry. No
No,
notice has
no.
been issued, nothing has happened.
no, my lord, my lord, this was the letter that I have obtained later, my lord. There is a notification, my lord. Please come to my lord, page 36,
Mr. Counsel, I hope you have understood.
my lord.
Or should I say in Assamese.
No, my lord.
Then the simple question is, have you applied? And if you have applied, where is any proof of that? Because the documents which you are bringing out here are documents pertaining to 2000 Bigha NK. Your address which you have put out there as a petitioner is 3000 Bighas NK.
My lord.
Your name is not reflected in any of these except the notice which was issued.
My lord.
So under what circumstances can this court come to an opinion that you have applied and your settlement is pending before the authorities? Because the moment the land is de-reserved, it becomes a government land. So he goes out, he comes in.
My lord.
The action is being taken by him, not him,
My lord.
not by the forest. It has been taken by Mr. Borua, along with Mr. Dutta. So how do you take care of that?
My lord, I'll take to your lordship to my statement. My lord, at page 5,
Of
my writ petition.
yes.
Page 5, paragraph 5, my lord, that consequently by order dated so and so issued by the jurisdictional deputy commissioner, it was made clear that it has been decided to grant settlement of land to 3 groups of people in 2 blocks, measuring 3000 bigha. My lord, that 3000 bigha, my lord, comes down here, my lord, and 2000 bigha. This includes total 5000. Total land is, my lord, 15,000. And it is specific reply by the.
Are you saying that there is a process of settlement to be given to those people and you come within it?
Yes, my lord. Yes,
How?
my lord,
Because you are 40 years old.
my lord, my.
If you are 40 years old, you were born in the year 1980.
I'm coming to that.
Then
My lord, since I have stated my predecessor, my grandfather, they are the farmer cultivating land there. That part of that statement.
so you come under which exception? You are not a landless,
landless.
but you have to have file an application before them.
We have
5,000 to the Revenue Settlement Department for settlement for landless people, and 10,000 is to be given for the Relief and Rehabilitation Department for settlement.
Yes.
Where do you come in?
3,000, my lord, that 5,000 in broader sense. We have for landless affected people.
How do we know?
My lord,
How do we know that this is a settlement to be done in this regard? Did you have anything to that effect?
I have, my lord, now at this moment, my lord,
What?
I have.
You filed in the year 2021 and till now you don't have anything. You have not filed anything. What remains in this petition?
My lord, in this case, my lord, in that case, Anayatullah Muzumdar versus 274 other, the petitioner in that case was my father. He was my father,
And what did the court order?
my lord. So it was at page, my lord, 35.
The petitioner may file necessary representation before the authority according to as dispose of the representation. Where is your representation which you have submitted? Or your father or your grandfather have submitted? Show me. The court didn't pass any order to that effect.
My lord, with my humble permission, my lord, this, my lord, from another court I come hurry, some affidavits are there, my lord, submitted by this petitioner, affidavits, because the process said, those who will fight affidavit, they will be, this is in the form of representation, my lord. So, my lord, I may be given only at least 1 day time, I will produce those affidavit, my lord. My humble submission before your lordship. Because one notification said you have the affected person have to submit affidavit. I beg your lordship apology.
Mr. Counsel, this court is not satisfied. What do you want? Should I dismiss?
My lord, at least 1 day given so that I can bring those representation, my lord.
Fantastic. When?
I beg your lordship, my lord. Tomorrow, tomorrow.
I give you some more
For the
period.
justice of, for the so that then, my lord, no prejudice can be caused to this villagers, my lord. Only, my lord. Till tomorrow, my lord.
You file a proper petition. Bringing all those things,
My lord.
not in this manner. You have not
Actually,
stated
my lord,
anything.
There is a huge document.
So what to do?
So, my lord,
If you have, there can't be huge document, you need only 3 documents for these 3 petitioners
my lord.
that you have not enclosed. How in manner that is, you have to bring before this
Yeah.
court that you have applied pursuant to the order passed by this court and that is still pending and they are now taking steps against you for evicting.
My lord.
That is your case.
My lord.
You should bring in. Where is that case?
My lord, yes. No,
Then-
I may be allowed to produce those documents, my lord.
How? 6 months.
My lord,
At the request of the petitioner, matter stands adjourned for 6 months.
much obliged.
Item number 3, order stay vacating.
Yes.
Petition lordship,
What is the order?
on at page 12, my lord.
Huh?
Page 12 of the IMR.
Which order you are saying? Until the next date, the notices dated so and so issued by the veterinary officer Guwahati shall remain suspended.
This notice
You are the petitioner,
no, I'm the respondent, my lord. I'm
respondent,
the
private respondent,
private respondent, my lord.
and you are the petitioner. What is your case, petitioner? Hmm. Issue notice for what? Situated populated locality. The cow dung and are seen to be stored nearby the cow shed and in this so and so. You are therefore here to remove the cow shed within 7 days from the receipt of this notice, failing which action will be taken as per the municipal corporation. So you are aggrieved by this. And this court had granted you a stay till the next date. Isn't it? Now, next date, there has been no extension. Huh? Until the next date, the notices dated so and so issued by the veterinary shall remain suspended. None appears for the petitioner, H. Sharma appears for me. The case is listed, writ petition was listed on so and so as an order was passed on so and so. Mistake has been coming to notice of the court after signing of the order. The case is listed before this court. The date of so and so shall be read as so and so. Then what else? There's no next date was 7/5. I for what? Who are you?
I'm the private respondent, my lord. We have been implemented, my lord. We are the respondents, private respondents, subsequently
Then?
implemented. My lord, we have been living in the nearby vicinity, my lord.
Okay.
The cow shed that they have been operating has been kept in an unhygienic condition. When the complaint has been made, I've stated in my, I've annexed the petition.
Okay.
Then
Now
when-
petitioner, what do you want? You have already enjoyed for 5 years in an unhealthy condition. No, why both you'll hear both parties is okay. But if he's doing something in an unhygienic manner, obviously they have to be removed. Within 1 month. For? We'll take it up at 2. You inform on which date the day will appear. No. You inform this court I will put it in the order and then they will appear. Otherwise, they will say that we have not received the notice. At 2, we'll dispose it of.
Item number 4.
You give me a date from whoever is going to take it. The TNA officer has to do it. No? So you take him because if this court fixes a date and he is not present, then there will be a lot of difficulty. So you take a date from him. When these persons will appear, hearing will be done and then finish. And I'm nothing will take. We'll take it up at 2. Just get that information.
Item number 4, permission.
Yes, who is appearing? You. It's okay, but what he wants that why the police is not taking action. That is what. If the cognizable case is made out, take action. If not made out, nothing is there. By you.
Taking all the development that taking place one after another, with regard to the sort of plan. So finally, there are like multiplicity of allegations one after another. First day there was a land grabbing case, then again given that fight for articles to whereby he has to get a corporation. Finally,
Full stop. Lahore. The instant petition has been filed by the petitioner being aggrieved by the inaction of the respondent numbers 5 to 7 in not taking any action on account of the inaction of the respondent numbers 5 to 7 in respect to Gorshuk PS case number, what is this case number? 16 oblique 2014, registered under section 447 IPC, read with section 5C and D of the Assam Land Grabbing Prohibition Act 2010 and Assam Land Grabbing Prohibition Rules 2013. This court had perused the affidavit in opposition filed by the respondent number 3. Through the Senior Superintendent of Police, City Guwahati. From the perusal of the said affidavit, it is seen that the respondent respondents in the police department have duly carried out the investigation. It is further seen that there has been also initiation of proceedings under section 133, 107, 145 of the CRPC. I
This is a
can't take up
separate
this
case.
matter. This fellow is there, this person is there. This has anything to do with Guneshwar Rajbangshi? Yes, I appeared for this fellow in respect to this matter only, not before me. No, because this matter I know I appeared the reported judgment that judgment, more particularly that RSA 144. Not before.
Number 5 and 6.
Wait, please, Your Lordship. The 2014 matter, my lord, on the last date, my lord, while hearing was going on, learned senior counsel for the other side wanted to get some instructions, so I don't know whether in this writ petition,
Yes, what is the case?
my lord, in this writ petition, my lord, I challenge.
Why are both petitions together same?
My lord, similar, my lord.
Okay.
Same.
Which one should we take then?
Let us take the first item first, my lord, it's item number 5,
What is that?
Behel Coal Traders, my lord.
Amul? Anmol?
No, my lord, Behel Coal.
Behel. Okay. Yes, what is your case?
My lord, here, my lord, we are challenging the and we are praying for a declaration that the terms and conditions, especially my lord, clauses 9 and 10 of the e-auction scheme be declared illegal, illegal, arbitrary, and violative, my lord. And so far as the facts of the case is concerned, my lord, there was a e-tender, and I participated in the tender along with others. I was at serial number 10, my lord, and thereafter there was one more behind me. There was a list, and then normally, my lord, they go by the list is also made seniority wise, price wise, and first come first basis. And normally they go by seniority wise. Now, when my turn came, my lord, the quality of the coal was so poor that it was not even marketable. But in the terms and conditions, they have a clause saying that you cannot refuse to leave the goods, saying that it is substandard of poor quality. Now they are saying that you refuse, therefore we gave it to, it was not of poor quality, just because you did not want, the market conditions was not suitable, so you just took a plea and you did not refuse, so your EMD will be forfeited. I also pray for refund of my EMD. Now, my lord, I understand that in a writ petition, I am within a certain boundary, my lord. Many facts, it may not be possible in a writ petition. But going back where I am, if, my lord, assume that what they are saying, that I just took a plea, market was not suitable and I did not leave. In that case, they being a state authority, they should have allotted to the next bidder, because he has paid a higher price and it's a steel grade coal. They do not even give a reason in the affidavit why they did not give it to the next bidder, but they supplied it to the NTPC, and NTPC takes low quality coal. They do not take steel quality coal, but they are silent on this also, which I have said in my rejoinder to their affidavit in opposition. Now, going by these facts, my lord, in my respectful submission, I at least make out a case that the quality was substandard, and that is why I refused. You cannot take recourse to subclause 9, and therefore I am also challenging that clause being draconian.
Is the spot e-auction scheme
My lord,
still prevalent?
it is, my lord.
Okay.
It is. That is at page 21, my lord. And
Now you are concerned with which clause?
clause 9 and 10. That is at page
Forfeiture.
for forfeiture, because they have they now want to forfeit my EMD because I did not leave the coal. And that too, it is at 500 rupees per ton.
Now, why you are, because the forfeiture clause will always be there. Why you are aggrieved by the forfeiture clause?
Because, my lord, this,
There has to be something,
my lord may kindly see a clause.
if after the completion of e-auction, a successful bidder fails to make payment for the coal,
Including
value including all other charges within the stipulated time, the proportionate PMD equivalent to the failed quantity shall be forfeited subject to the provisions of 6.4 and 6.5 of the document. What is wrong with the document? Clause 9.1.
My lord, this I can show what is wrong only if I can place the next clause, my lord, general terms and conditions, my lord,
Where?
at page 26.
Page 26,
11.8, my lord.
11.8.
There will not be any joint third-party sampling facility extended to any buyer. Refusal on account of non-suitability and or substandard quality for the allotted quantity of coal shall not be acceptable.
Hmm.
This, in my respectful submission, is a draconian and very highly arbitrary clause set by an authority where they exercise monopoly.
No, first show me why will a person bid? At the time of bidding,
My lord,
are you informed of anything?
at the time of bidding, my lord, they
Let
do
us
not-
see. No, kindly come to clause number 3.
my lord,
Northeast Coalfield would draw program for conducting at least 2 e-auction per month and notify the same minimum 7 days in advance to display on the company's notice board and putting the same on the coal company's website for program. There will be a separate auction for dispatches by road. One quantity for the bidding with 50 tons for RTM. Any rail. Yes, kindly come to 4.2.
my lord. The buyers while bidding coal shall quote the price per ton in Indian rupees.
No, 4.2.
Very sorry, my lord, very sorry. Before participating in e-auction, bidders are to satisfy themselves with the quality of coal being offered from a source. My lord, for this, my lord, I have made a statement, my lord, in my petition that they did not even have the quantity of coal extracted from the mine when they issued the e-auction notice.
So did
there
you
was-
why didn't you raise that issue when you filed your prior to submission of the bid? You should have raised that issue.
My lord, very true, my lord. When there is a monopoly, my lord, and they are the only ones, my lord, either you bid or don't bid, it doesn't matter to them, my lord.
Understood very
That
well,
is the
but you have to
situation.
inform them that look here, we are not in a position to do so because these things are not available. That could have been a good ground for
That is
moving a writ. But because you have to read 11.8 with 4.2.
Yes, yes.
And if you are to satisfy yourself before bidding,
Hmm.
then after bidding, you cannot say that, no, look here, I am not going to lift. So what is wrong with the clause?
With the clause per se, if you see the clause per se, my lord, there is nothing wrong. My lord may also see.
It may be in that particular facts,
Yes,
this is wrong. But
Yes.
for that, how can you challenge the scheme?
my lord, I'm not challenging the whole scheme, my lord.
So unless you show that
My-
clause 4.2 was not complied with, in fact, there was no opportunity given to you to inspect the coal prior to that, will be a cause of action which will be distinct, which means the clause 4.2 was not complied, and as such you can't bring in 11.8.
My
That is another case.
my lord.
But how do you challenge the scheme?
My lord, if it was a situation that they already had the stock of coal and there would have been inspection, my lord. In that case, that the other clause, my lord, 11 clause at clause 11, my lord, that you cannot later on take a plea that it is of not substandard quality. But when the coal itself is not available, and they have not stated in their affidavit also that the coal was there and it was open. to
Did you
inspection.
raise the coal was not there
I-
prior to submission of the EB?
That I did
These
not
are the
do.
various terms and conditions. You knew it that you are to inspect. If no inspection was granted, did you raise the plea out there? Why no inspection has been granted?
That I have not stated, but I've stated in my petition to which they have not replied.
No. But
Yes,
did you,
I-
why haven't
I
you
did
raised
not.
that issue?
I did not do
So
that, madam.
under such circumstances, reading 4.2 with 11.8, how can you say 11.8 is wrong or even clause 9 is wrong? Because if you don't lift, obviously there will be a what you call EMD forfeiture will always be there. That is there in all contracts.
No,
It is
ve-
something
very
like
correct.
this. The conditions, an act may be good, but a statutory enactment may be good, but the government or authorities are not complying with it,
My
for which it cannot, the act cannot be bad.
Madam.
Then now, therefore, the question is EMD violation, unless you have raised that issue earlier, why not the EMD violation? Where is the question of violation of EMD?
This I have not raised it earlier, my lord. I leave it to my lord, but I take this plea that I did not raise it earlier because it's a competitive market and they have a monopoly on the market. There is no other option that I have available that if I don't bid, where shall I also go? And secondly, my lord, one
And Ms.
Madam,
Goyal, don't you think that if you give a representation that I want to inspect the
Yes,
coal
yes,
and they don't give, wouldn't that be a cause of action for filing a writ
yes,
petition,
yes,
which
yes,
you did not do?
I did not do. Yes,
Then how do you assail this?
but one question still remains, whether I get my EMD back or not.
How do
my
you
lord.
get your AMD when the clause or you have agreed to that if you don't lift it, then they will impose the EMD to the amount which have not been lifted?
My lord, but still one question perhaps would remain, my lord, being this a writ petition and they being a state authority, I take it that I am not entitled to the EMD. And from what my lord said, I had options, even if not before bidding, soon after bidding, I could have filed a representation, which I did not do that. And I realize now that, okay, I did not take that opportunity. But they giving it to not to the second bidder and giving a high grade coal, steel grade coal to a non-steel grade coal at that same price without charging the price, my lord. That in my respect.
Was there any risk and cost imposed upon you?
My lord,
Was any risk and cost imposed upon you? So where did they give it to whom? How are you bothered
my lord,
after not lifting it?
it's a writ petition, my lord.
Understood.
It's a writ petition, my lord. They being a statutory authority, my lord, are they empowered, my lord, to just dole out to anybody? It's a value of that state authority which they doled it out to a price of much less than around 2,000 rupees per ton less, my lord. And it's not it's around more than 2,000 tons, my lord. I believe, I think this should answer, my lord, which they have not, my lord. They have avoided that query, even though I have raised it specifically in my petition.
How is a prejudice being caused to you?
My lord, this being a writ petition, my lord,
No,
what
the
I'm-
petition
what
will look into it,
My
but
lord.
how is the prejudice being caused to you?
My lord, my lord, this is what I'm trying to show, my lord, because it was.
Because now they have already given, Ms. Goyal, first they have already given that coal must have burned now,
Yes. Yes, I'm
2014.
aware of that.
So the coal has
Yes.
already burned. Now the remaining even the ashes is also not there.
My lord,
Now the question is, what do I do with them? Not to give it at a later stage.
I understand the situation, my lord. My lord, from what is falling from my lord, one definitely a strong inference
But
that can be
Ms.
drawn.
Goyal, what you are submitting,
My lord.
if this court was appointed In the year 2014, I would have passed the order. But not there, I'm not there.
My lord, I'm aware of my situation, my lord, very well aware. But one strong inference that we can draw, my lord, because it was not given to the next bidder and it was given to a low grade purchaser, one strong inference that the quality was not of steel grade, my lord. That I still stand by that, my submission, my lord. And
No,
I
but-
leave
but,
it to my
no.
lord, my lord.
Very well understood. It is given to somebody else. That is another thing. But the question is regards the quality which is there. If it is bad or worse, whatever it may be, you have been satisfied in view of clause 4.2 and therefore bidded.
But they have not stated that the coal was available, my lord. Nowhere in the affidavit they
Understood,
have
but that
stated.
is not your case.
My lord, I've stated that. my lord.
No,
Yes, I did not inspect. Yes,
Then
yes.
you
This-
open
this-
eyes participated and
Yes,
then
yes.
now later on when the EMD is being imposed, you have done it. Now what is happening thereafter? You must be always doing this business.
Yeah, I know, I did that next auction again, I bid it and I took the coal.
You got it.
Yes, I got it.
And then did you ask for inspection prior to that?
And my lord,
Then-
that no one does, but now I am wise, my lord. Now after bidding, soon after bidding, like we can file a representation. This wisdom I got at least, my lord, from this petition. But one fact, my lord, I still, my lord, we cannot leave it so much to the authorities to do whatever they want. Since it's a writ petition, I plead that this honorable court.
Ms.
may
Goel,
invoke
why don't you bring in respect to a fresh cause of action, something like that?
that I will do, my lord. Now I have become
Then we will
wiser,
take
my
it
lord.
up on that, but not here.
I leave it to my lord, my lord.
The instant writ petition has been filed. Both the writ petitions, both are same.
My lord. Only I think auction date is different. Both are same.
No, okay. But both the writ petitions, the EMD has been
Same,
forfeit.
same. Except the auction date.
Both the writ petitions has been filed. No, anyway. Taking into account that the issue involved in both the writ petitions are same. And the facts also paramateria. This court takes up both the writ petitions for disposal by this common judgment in order. The petitioners in both the writ petitions are registered you are registered under what?
I am registered to participate in the e-auctions, my lord.
Are registered for
My-
participation in the e-auction, in the auction for sale of coal by the Northeastern Coalfields. Northeastern Coalfields Limited. At this stage, it is relevant to take note of that the Northeastern Coalfields Limited has a scheme for coal distribution through e-auction. The said scheme is known as the E-auction scheme 2007.
May I just one small interruption?
In the backdrop of the above,
Before my lord proceeds, and I point out later, sorry for the interruption. And in the second case at paragraph 11, it is stated that the petitioner, he made inquiries because within the 45 days time, he was not given the delivery. And he made inquiries and they informed that the coal was not available. So that is there in the second. case.
but then why did you participate?
And that is after the bidding.
Huh?
That is there, I'm just pointing out the fact.
I'm now coming to the facts.
Right.
In the backdrop of the above, let this court therefore take note of the facts in each of the writ petitions. The petitioner in WPC number 3500/2014 had in pursuance to a notified auction sale of coal vide the notice dated 16/1/2014 participated in the said e-auction. It is the case of the petitioner that the petitioner deposited EMD of rupees 13,75,000 for 1 rack of coal of the grade and quality mentioned in the grade G1 R all caps ROM, exceeding 7,500 K dot cal kg and not exceeding 7,600 K dot cal kg. In the said e-auction, the petitioner was placed as serial number 11 out of 12 successful bidders. This court at this stage finds relevant to take note of Annexure Roman 3. Of Annexure Roman 2 and Roman 3. What is this Annexure Roman 3? Which is the bid list, bid sheet. Issued on 16/1/2014. In the said bid sheet, the petitioner's name appeared at serial number 11, and the petitioner was allotted a quantity of 2,750 metric tons. At the price of rupees 6,550. Per metric ton. And the total value of the allotment made in favor of the petitioner was rupees 236,33,582.66. It further appears that on the very date a sale intimation letter was also issued. What is this? How is this different from that?
My lord,
Annexure Roman 3
my lord.
says about allotted quantity is 2,750,
My lord.
or is it the total? No.
Here they do not mention.
Now, why serial number 4?
2750. In the first column, the.
No, the serial number 4, annexure for Roman 4, page 29, if you see.
My lord,
GI ROM exceeding 7,500, now allotted is 730.
my lord, this does not belong to us.
Huh?
This does not belong to.
It doesn't belong, it belongs to your company name on top, well.
Audit. Yes, okay. Yeah, this comes to only 1,500 metric tons.
No, it is this is different. You see, on top at page 28, MSTC/HO Northeastern Coalfields -Rail/2 Margarita
Margarita.
13/14/268.
My lord,
And this is different. MSTC/HO Northeastern Coalfields 3 Guwahati 13/14/269.
my lord, because this is from Margarita office, this is from Guwahati office.
Now these are both different. It can't be the same.
It is relating to that same auction.
It can't be because the auction is different. Now you see on top,
Uh,
page 28 on top, see the number. It's the last is 268.
13/4/268.
And this is 13/14/269.
It has to be by road auction. that
So
happens.
this is different from that.
It appears to my lord. Yes, my lord. I did not notice that much. Yes, my lord.
Further, it appears that in respect to another e-auction, the petitioner was also informed by a sale intimation letter that the petitioner had been allotted 730 MT at the rate of rupees 6,100 per metric ton and 770 metric tons at the rate of rupees 6,130 per metric tons. The respondent, who's the next? On the ground that the quality of the coal which was allotted to the petitioner on the basis of the two e-auctions was not of the requisite quality and marketable. The petitioner refused to make payment of the coal value and consequently the respondent company forfeited the EMD so submitted by the petitioner. Being aggrieved, the petitioner has approached this court challenging the terms of the e-auction scheme 2007 and more particularly to clause 11.8. Next one. It উপৰত হ'ল WPC number 3500/2014 বুলি দি দিব এইটো এতিয়া এইটো হ'ব WPC number 5110/2013. The instant writ petition has been filed by the petitioners by 4 petitioners jointly who are registered with the respondent number 1 company for purchase of coal through auction.
But I think my lord may deal with this fact separately, my lord. Because here factually, it was not lifting of coal, it was that they did not deliver. That is better. Here there was no forfeiture. They refunded the money without supplying the coal.
Madam, why are you challenging here?
My lord, here because they have a validity period of 45 days. Once the successful food list is out, from that day, 45 days. Now within 45 days, we need to live. But they have to deliver for us to live. They did not deliver and they refund us the
So why
money.
you are challenging the e-auction?
That this 45 days validity period, if it is for their fault, they should not default the list. They should supply the goods. They keep the money for 45 days and thereafter another 10 days, 15 days, and they refund the money. And without paying interest
No,
on that
but
money.
this is in accordance with as per, let's see the scheme. So how is that petition same with now? It will be with the,
We
this
can
is different,
segregate-
huh?
Segregate, but it can be
This is
this also can
segregated.
be disposed of. my
no,
lord.
this can't be the same.
Yes,
This will be on a different.
different factual.
সেইটো লিখিল,
matrix.
হা? এই আগৰখিনি সেইখিনি লিখিব, এইটো বুদ্ধ petition সেইখিনি মিলাই দিব। From a perusal of the petition. No, the Miss B. Goyal, the learned counsel appearing on behalf of the petitioner, submits that clause 11.8 of the bidder cannot, on account of non-suitability and or substandard quality for allotted quantity of coal, cannot refuse to lift. She submits, the learned counsel submits that although clause 4.2 of the said of the scheme of 2007 permits, gives an option to the bidders to satisfy themselves with the quantity of coal being offered from a source before participating in e-auction. But in effect, no opportunities as such are given to the bidders. After issuance of the notice of sale, notice of e-auction, the learned counsel submits that as that opportunity is not granted, that bidders like the petitioner in view of the monopoly of the respondent company have to participate without being given the opportunity to satisfy the quality of the coal being offered from a source. It is therefore the submission of Miss B. Goyal, the learned counsel, that when no opportunity is being granted to inspect the coal prior to participation in the e-auction, the clause 11.8 of the scheme of 2007 holding that the bidder cannot refuse on account of non-suitability and or substandard quality for allotted quantity. And if refused, the consequences of forfeiture of EMD on the basis of clause 9 of the scheme of 2007 is absolutely arbitrary, unreasonable, and as well as irrational. The Learned Counsel therefore submits that as the scheme of 2007 therefore submits that the scheme of 2007 infringes the provisions of Article 14 of the Constitution. Mr. M.J. Ahmed, the Learned Senior Counsel appearing on behalf of the respondents, on the other hand, submitted that the petitioner herein knew the terms and conditions. Petitioner herein is a regularly participates in the auction process. He knows about clause 4.2 of the scheme of the petitioner knows very well about clause 4.2 of the scheme of 2007. And did not complain or submit any representation, and did not complain or ask the respondent authorities that the petitioner wanted to inspect the coal prior to participating in the coal auction. The Learned Counsel further submits that the petitioner, knowing very well the provisions, the scheme of 2007, have participated and thereupon, for best reasons known, the petitioner did not want to lift the coal by making the payments. Under such circumstances, the forfeiture of the EMD so done was in accordance with clause 9 of the scheme of 2007. And as such, no interference is called for in respect to the writ petition. In respect to the writ petition. Anything else, Mr. Ahmed?
Only one correction on factual Fatah's last sentence, my lord. He paid the money because within 7 days we have to pay the total value. That money was refunded, only EMD was forfeited. Last sentence.
When did you pay the money?
7 days we have to pay, my lord. That's a mandatory requirement.
Then
within
if you,
7
why
days of
did
the
you,
list.
if you have paid, then why is the EMD forfeited?
My lord, because I did not leave.
Ms. B. Goel, the learned counsel rejoining to the submissions of Mr. M.J. Ahmed, the learned senior counsel, submitted that the petitioner duly made payment of the total amount. But as the petitioner did not lift the coal on account of the quality of the coal being not good and marketable within 45 days, the amount so deposited by the petitioner was refunded, but the EMD was forfeited. Next. I've heard the learned counsels for the parties and also have perused the materials on record. From the perusal of the materials on record, it appears that the forfeiture of the EMD was in accordance with the scheme of 2007. And this aspect of the matter is not in dispute. The dispute involved herein is as to whether clause 11.8, which imposes upon the bidder, which does not leave any option to the bidder to refuse even if refuse on account of non-suitability and or substandard quality for allotted quantity of coal is arbitrary, unreasonable, and accordingly violates Article 14 of the Constitution. This court finds it relevant at this stage to take note of clause 4.2 of the scheme of 2007. The clause 4.2, clause 9, and clause 11.8 of the scheme of 2007, which are pivotal for the determination of the issue involved in the instant proceedings. The same are reproduced hereunder. It'll probably page 22, 24, 26. From a perusal of the above clause 4.2, above quoted clause 4.2, it will show that a bidder has an option to satisfy themselves with the quality of coal being offered from a source before participation in a e-auction. Meaning, the above aspect therefore means that merely because the bidder is registered with the respondent company as a bidder for e-auction, it is not incumbent upon the bidder to participate. The bidder has an option to participate or not to participate, taking into account the quality of the coal being offered from a source. The learned counsel, appearing on behalf of the petitioner, though had submitted that there was no opportunity given for the purpose of inspection of the said coal, so that the petitioner could satisfy itself with the as regards the quality of the coal. But there is nothing on record except a mere statement being made in the writ petition. But there is nothing on record that the petitioner had approached the respondent authorities seeking that the petitioner wanted to inspect the coal, the quality of the coal. Now coming to clause number 11A.8, which in the opinion of this court is a result of clause 4.2. In as much as the bidders participates in the e-auction with open after being satisfied with the quality of the coal being offered from the source. Clause 11.8 mandates that upon being offered the said coal, the bidder cannot refuse on the ground of non-suitability and or substandard quality. In the opinion of this court, that as in the as clause 11.8 is consequential to clause 4.2. The said clause 11.8 cannot be said to be arbitrary and illegal, and as such violative of Article 14 of the Constitution. Clause 9, which have been quoted here in above, stipulates that if the successful bidder fails to make payment for the coal value, including all other charges within the stipulated time, the proportionate EMD equivalent to the paid quantity shall be forfeited subject to the provisions at clause 6.4 and 6.5 of the document of the scheme of 2007. Clause 9.2 is in relation to the bidder not lifting the board booked quantity within the stipulated validity period. Then the proportionate security deposit at the rate of rupees 500 per ton for coal from the GCB more than 4,300 KCL oblique kg and at the rate of rupees 400 per metric ton for coal from having GCB of 4,300 KL per kg and below, as converted from the EMD amount for unlifted quantity would be forfeited. Taking into account that the petitioner failed to lift the coal within the say period, within the stipulated period, this court is of the opinion that the actions on the part of the respondent authorities in imposition in the forfeiture of the EMD cannot be interfered with. Consequently, this court does not find any merit in the writ petition, for which the instant writ petition stands dismissed. So it is, however, made clear that this court had not made any observations, that the instant judgment and the observations made herein would not preclude the petitioner to challenge the actions of the respondent authorities if in a given case the inspection sought for was not granted.
Grateful, my lord.
I'm coming.
I was waiting for them to dispatch the coal. But instead, what they did, after 45 days elapsed, they said since 45 days has elapsed, and therefore we will refund you the money. Now, this is not just the only case. They had been doing this in a series. So the issue that I raise is that you being a public authority, you do not even have the stock of coal. In fact, if I would have argued this, it would have helped my other case. You do not even have the stock of coal. You notify auctions, you make people pay money, and 45 days elapses, it doesn't matter to them, and you refund the money. And it's not small money, means it's 2 crores, 5 crores money, my lord. And it is not that they refund the money immediately on 45th day or 46th day. They take their own time, take 10-15 days, my lord. My money also has value, my lord. They forfeit
So
EMD.
they forfeited the EMD.
No, here they did not forfeit because they failed. Here they refunded me the whole money. But you refunded me the whole money after 60 days, keeping my 2 crores, 5 crores of rupees. This, my lord, this cannot be permitted, taking recourse to the terms and conditions. Now I
Why
come
are you challenging clause 9.1?
9.1 because it says
But you,
9.1 and 10 also, my lord.
no, why are you challenging 9.1?
My lord, because 9.1,
You have made the payment.
yeah, I made the
Then why you are challenging 9.1?
9.1, my lord, because if after completion of the e-auction, there's a mandatory requirement that within 7 days I'll have to make the payment. If after completion of e-auction, a successful bidder fails to make payment for the whole value, including all other charges within the stipulated time, that is 7 days, the proportionate EMD equivalent to the failed quantity shall be forfeited subject to provisions of clause so and so. Now, if I don't pay them the money,
But you paid.
I pay.
Then why you are challenging 9.1?
Precisely, I'm trying to make out my point. Now, within 7 days, you have a clause that if I don't pay the coal value, total coal value, you will forfeit my EMD. Now, if I follow this 9.1, then what is there in 10? If within 45 days, within the validity period, they will not give, they will refund the money. You cannot have the cake and eat it too. Either you do it this way that, okay, I pay the EMD, I participate. And when you have the stock, you notify, we pay the money and we lift it. And if I don't lift, you forfeit my EMD.
Clause 10 says the balance coal value of the unlifted quantity.
Yes. Even if they fail to provide, they consider it unlifted.
How can they
quantity.
consider it?
That is why exactly my,
No, so clause 10 is okay, but the action is wrong.
yes. So taking recourse to clause 10, they cannot say unlifted quantity which you have not even provided. And therefore, my lord, prayer will be in the circumstances now where
Because
I
if
am
you see
at this stage,
7.2,
my lord.
the validity period to complete lifting of coal by
Yes, sir.
roads shall
Yes.
be 45 days from the date of issue of the sale
7.5, my lord. Here 7.5 will be relevant, but it is more or less the same.
of the square. So validity period for seeking allotment of the shall be 45 days from the date of issue of the consent by non. One rack is allotted shall remain valid for the supplier as per the prevailing. So it will be 45 days and they did not. Now you say that because of that, you should be entitled for the interest for this particular period.
For the time, not only 45 days, till they paid because they withheld the money.
Till you got the refund because it was their fault.
Yes.
So for that, you don't need to challenge this. You
My lord, as a precautionary measure, I do
no,
this.
no precaution business. Yes, Mr. Ahmed. Now your thing comes.
That's what they pay the entire.
Huh?
They have to pay the entire pay. That's the. But if the 15 of.
No, there is no forfeiture of EMD here. Here is a case.
The refund of full pay.
You have refunded the amount, but it is because of your fault. You did not give her within 45 days, and thereafter you said that okay, take back the money out there. Now she is asking for that. Why am I not entitled to the amount, interest on the said amount from that particular date till the date of refund? That's your case.
Yes.
In this was not revealed
They leave because of variable. That's the reason. You the but petitioner was. And that is. Where? That the state which funded. The better particularly with unlimited quantity after the expiry of credit period or supply of goods and consumption of what shall be refunded subject to officer of. This is only for the purpose of unlifted quantity. Unlifted means when you offer, he or she has not lifted. Then only the question of unlifted will be there. But when the material was not available, where does the question comes from unlifted? Vera? That having perused the various averments of the writ petition and have understood. Paragraph? Now, if that be so, no, here you say all terms and conditions of the scheme are subject to force majeure conditions as applicable. Very well. Now, this force majeure condition of 11.2 will be applicable. Now, what do you say? That means if it is not available, how do you give for inspection as per 4.2? If you don't have the coal, there's no case there, but on one hand, 4.2 says that you have to, they have to be satisfied before entering. Now they have entered into and submitted, meaning thereby that you have to have the coal before issuing the e-auction. How did you go for e-auction otherwise and have taken the money and then refunded without paying off compensation? There's a loss. They must have done it with somebody else. So you have to pay interest. Hmm? Understood, but for that particular amount what they have paid, don't you think that they will be entitled to something because it is on your failure this has happened? Now, is there any clause out there in the scheme that if the coal is not available, then it is not required for the respondent company to supply and they will refund? If that is not there, then and if we go by 4.2 that they have to be satisfied before e-auction participating, don't you think that they will be entitled to for the interest on that amount? No, they are asking that is only, isn't it, madam?
Yes.
They are asking 12% on that. They are asking many other things as a matter of abandoned caution. But that's a different thing which is not required. But the question is why they are not entitled to the interest. Hmm?
The family part. The two by. And then the system category. Have been. You. They have paid it. They paid it. Big bill and after. You. And. Okay, but they do. But they may not. Fulfill the whole product here. The forecast that. So have to put in the weather conditions. Not
Show us the terms of your e-auction notice. Where is the e-auction notice? Dated 12/1.
Page 25 in the repetition.
Page
25 in the.
No, that's the scheme. I'm not on that. E-auction notice. Yeah. 26.
Page.
Page 26.
31.
No, page 31.
Get up.
No, you should have, if you didn't have the coal, why did you accept the money? Because they have the period of 7 days to deposit.
Yes.
After the sale letter. Why did you issue the sale letter to them? If you didn't have the coal. Understood. Okay, I understand that at the time of notice inviting quotation or something, you may not have the coal. Then they submit their bid. You are to issue a sale intimation letter. And with the sale intimation letter, within 7 days, they are to deposit. They deposit that amount. Now, after deposit, why did you issue the sale intimation letter if you didn't have it? Then also you should have said that no, we are not issuing. Knowing fully well you didn't have the coal, why did you issue the sale intimation letter? Okay, Mr. Ahmed, we'll look into it. We'll take it up on 10th. I'll pass the judgment in your presence. If you have 10th. 10th of August.
Right.
Matter has been heard at length. This court had put a specific query upon Mr. M.J. Ahmed, the learned senior counsel, appearing on behalf of the respondent, as to whether the respondent authorities were justified in issuance of the sale intimation letter and thereby directing the petitioner to make payment within 7 days. And after receiving the said amount and not supplying the coal to the petitioners on the ground of non-availability of coal. list the matter on 10/8/2000 for final discussion. No. 10. You want to do it tomorrow? Today I have to take other matters. That is why I am not. Otherwise, I would have passed the judgment. You have to pay interest. Now only find out how much is the interest. 8 or 12%, because this has a far-reaching consequences. That is why I've given you time. Because tomorrow, if I pass an order, every time you do all these things, you'll be liable for interest.
Let's be careful.
Because you shouldn't, whatever may be, because their their liability to pay comes within 7 days from the date of sale, intimation. Why did you issue the sale intimation if you had no coal? Or in anticipation that you will get coal, you will do it, because in your notice, you have categorically stated that 13,750 metric tons is available. On
I'm
10.
grateful, my
I know 7 and 8.
Yes.
May it please your lordship. The petitioner is challenging the order passed by the respondent number 1, your lordship, who is acting as the second appellate authority.
What order you are challenging?
Your lordship will find that page 51, your lordship.
Which item?
7 and 8, your lordship.
Understood. Guwahati Carbon 36. Guwahati Carbon.
Yes, your lordship, 3608,
You are challenging which
51, your lordship.
27/5/2014.
Yes, your lordship.
Passed by the respondent number
Number
1,
one.
central information, and the order dated demand passed in appeal, passed by the so and so as set aside, to be set aside. Who are you?
I am a limited company, your lordship.
Okay. Then
The respondent number 4,
which order you are saying? Page 26,
51, your lordship,
26, 51.
is the impugn order, your lordship. Passed by the respondent number 1, who is acting as the second appellate authority, your lordship.
Yes. Yes, tell me.
The respondent number 4, your lordship, had filed an RTA application
Hmm.
at page 16, your lordship, 14, your lordship, annexure 1,
Annexure,
1, your lordship,
page
14, your lordship.
14. Yes, kindly intimate the details of excise duty paid by so and so from so and so till date. With respect to the question 1A, kindly provide me a year-wise statement containing the detail of excise duty payable. 8. With respect to question also furnish me a year-wise statement pertaining to the details of rebates, benefits, if any, given to me. With respect to the question in 1C, with regard to 1C, kindly let me know whether the company has provided details of equipments, machinery, plants, and installation to the central prevailing benefits. A list of areas, so and so. A lot of questions. Then,
Yes, your lordship. Total 24 numbers of questions, your lordship.
then,
It was regarding to the third party.
then what happened? This application, what is the answer?
Annexure, your lordship will find an annexure to page 17.
Hmm.
As the information was sought from the third party, your lordship, the authority has.
This is
written
for your
letter to the
information that
petitioner, your
one application under has been received from so and so, requesting the information year-wise details of the amount of excise refund received by you unit with effect from so and so under notification dated so and so. So that is only the,
Yes, your
how
lordship.
much refund you have got?
Not only that, your lordship, there is the secret, the trade secrets of the petitioner company, your lordship. The respondent number 4 has sought information from the petitioner, your lordship, regarding the trade secret refund got by the petitioner.
Is it a trade secret?
It's a limited company, your lordship.
Is it a trade secret as regards how much refund you have got? Isn't it the public money?
That's the public money.
Are these refunds not on the basis of orders being passed by the central excise authorities?
Yes, your lordship.
Then what is there?
Your lordship, then your lordship.
Have you seen the constitution bench judgment?
Yes, your lordship.
Then what does it say? Does it help you? It does not. It goes absolutely against you.
Then your lordship, the petitioner had written to the respondent number 2, your lordship, at
Hmm.
page 18.
Hmm. How is it technologically fiduciary? These are all orders. Now you are asking that you should be given benefit under 33, notification 33/99, on the basis that you have made certain addition or diversifications or increased in by installing plant and machineries by 25%.
Correct, your lordship.
And it is on the basis of that there is an order being passed
Yes, your lordship. We are on the,
by a functionary.
correct, your lordship. We are on the action of the respondent number 4, who is nowhere connected with the petitioner company, your lordship.
You'll know after you get that order, what is he going to do?
That too, the respondent number is a resident of Howrah, your lordship, not
So what?
within the state of Assam, your lordship.
Eh?
And even when the,
These are documents which are available. They have to pass. These are, I would have understood if it is a document between you and some private people. But you have asked for, made claims for exemptions, and these exemptions have been duly granted on the basis of orders passed by public authorities.
correct, your lordship.
And if you see their order which will be passed, thereby making you an eligible unit, there also it will be categorically mentioned that what are the plants and machineries installed for the purpose of granting the benefit of eligibility. Then these are all orders of the public authorities.
That's correct, your lordship. But the action of the respondent number 4,
So what?
who is nowhere connected with the petitioner company,
It
that
is
we have
required.
challenged. And your lordship, even the section 19(4) says, once an appeal is filed, right to a hearing has to be given, the opportunity has to be given to the petitioner company, your lordship. That was not given, your lordship. As per 19(4) of the Act, your lordship. Even that we have intimated the officer concerned, your lordship, if any appeal is filed, right to hearing has to be given.
Right to hearing has to be given when?
At the appellate stage, your lordship.
When?
Section 19(4).
No,
your lordship.
when?
If the appeal is filed. By the
When? There is a requirement when. In all appeals, it is not required. When it touches on 8J or I or E or something like that. Not always.
Even 8D says that I am covered under 8D, your lordship.
What is that?
Information including commercial competence, trade secrets, or intellectual.
What is
property.
this commercial confidence out there in this thing?
That's the
Well-
secrets of the company, your lordship.
Thing out there. Yes, Mr. Kyle. You have given, haven't you given it, are these not public orders? These are public authorities who have passed these orders. The orders, these authorities categorically said that these are the reasons why he is eligible. These are the plants and machineries installed. This is the refund every month. This notice is being issued and then it goes to your account and you get the refund. These are all orders being passed by the Central Excise authorities. Well, then nothing is there.
That to the information, we have categorically stated in the petition that the information is passed by the respondent on the BS of our rival companies. your
Mr.
lordship.
Das,
Yes, your lordship.
these things would have been tenable at a time when the judgment of various courts, more particularly the Supreme Court in the case of this Bandyopadhyay, Ajit Bandyopadhyay was there. But all have been watered down by the Constitution Bench judgment. Isn't it?
But that too, the opportunity of hearing was not also given in the appellate stage, your lordship.
So you are now, I'm hearing you. Tell me. Give me a good reason why you should. These are public orders. I would have understood.
Correct, your lordship.
You, whatever you are, how much, what secret deal you had with that particular person when you are buying that particular plant and machinery, that's cannot be given. No quarrel.
Correct, your lordship.
But if you are claiming that benefit, that this is the amount, this 100 rupees or 200 rupees at which I have purchased this particular plant, and as such, it exceeds the 25%. And therefore, I am entitled to exemption under the notification of 33/99. The authorities thereupon has to pass orders on that.
Correct, your lordship.
And the authorities categorically mention out there in the orders that look here, that he has invested, this is the amount, these are the plants and machinery, this diversification which has happened. And as such, they are entitled or eligible to be so and so. These are public authority orders.
But the lordship, that's to a third party information, your lordship. As per
What
section-
third-party information?
Section 11, your lordship. The respondent number 4 is seeking information from the authority concerned regarding trade secrets of my.
Mr. Das, you have not 100% read the constitution better. What is third-party information? Are you aware? What is that? You read the justice, the opinion of Justice Chandrachud in that judgment, wherein it says that what are third-party information? Third-party informations, everything is not third-party informations. That is why the third-party information will be an information if you ask them. Then look here. What is the deal by which Mr. Das had with him at the time of purchasing? That is a third-party information where they can't divulge. But what are the informations asked here are all on the basis of public orders being passed.
That's correct.
And what is the other same?
Same, your lordship.
No.
The dates are different.
What is that judgment, Supreme Court? You have it? The Constitution bench?
Constitution, I don't have, your lordship, but I have 2013 4 FCC.
Huh?
2013.
No. What is that? Bandubadhyay?
Yes, it's passed by Justice Mukhopadhyay, correct, your lordship.
That is been watered down. There are few more judgments thereafter, wherein what are the expenses, medical expenses of judges? These have been asked. They say that what is all these things which are required? Is another judgment of that. What is that? CIC versus Register of so and so. I forgot the name. Yeah, that one. Subhas Agarwal. Got it. Well, who is appearing for respondent number 4?
The council used to appear, but from after.
He must have
2000
been fed up because of the stay.
No, your lordship, the senior council has.
Understood, but there is a stay.
After the elevation of the senior council, they refused to appear, your lordship.
Huh?
Justice Manish Chaudhary was to appear for the respondent number 4.
Uh,
But after his elevation, the juniors said the brief has been taken away. We have no contact with the client.
well, I advocate it for him. What do you say, Mr. Gogoi? On this Right to Information Act? Hmm? Hmm. Twenty. Third party information which is there, na, the Supreme Court says you are claiming under 8(1)(d).
Yes, Your Lordship. 80, section 19(4), no opportunity was given at the appellate stage, passed by the respondent number 4. You know, even the second paragraph, 11, section 11(1). Seeking information, Your Lordship, will not provide the larger public interest as stated in 8(1)(d), Your Lordship.
Now, what is the observations made by these authorities?
Observation made by the first appellate authority, you'll find
You
in page
view that
20,
there
Your
is
Lordship.
no legal flaw in the FFA as such. Hereby Then,
Central public information.
where is this?
Observation
Facts
at
of the
page 20,
case,
Your Lordship.
central excise,
Yes, page 20, Your Lordship.
huh?
Page 20 of the petition.
20.
Yes, Your Lordship. Was observation made by the CPI, Your Lordship.
Let us see. Was any notice given to you? Yeah.
Yes, Your Lordship.
They denied the disclosure of the
Because it
information
relates
sought
to a
to
third party
the
information under section
appellant
11, Your Lordship.
either under D, holding that to be exempted under 8(1)(d) and demand that the information was related to third party could not be revealed in the light of when he has also held that in view of the pending state not So you are challenging the 15th December 2011.
27/5/2014, your lord.
No,
passed
you
by
are
the-
not challenging 15th December.
No, your lord. That is
Page 26.
Yes, Lord, this is the first appellate authority. Then
So
appeal was
you
filed by-
you have challenged this.
Yes, that no opportunity was given to the petitioner company, Lord, under section 19(4).
Then thereafter,
Then second appeal was filed by the petitioner company, Lord,
then
thereby upholding the order passed by the first appellate authority.
then what
That
happened?
is under challenge, Your Lord.
No. Then what order has been passed?
Your Lord, you will find it page 51, Annex 8,
Page 51.
51, Your Lord.
You see, what is third-party information is given in paragraph 261 of the judgment. The definition of a third party includes a public authority. Third-party information is an information which relates to or has been supplied by any other person, including a public authority, other than the information applicant, and has been treated as confidential by such third party. Where disclosure of a third-party information is sought and such disclosure has been prima facie treated as confidential by the third party in question, the procedure under section 11 of the RTI Act is mandatory. The information officer shall, within 5 days of receiving the request for third party, notify the relevant third party to whom the information relates or which has been supplied. The notice shall invite the third party to submit reasons in writing or orally as to whether or not the information sought should be disclosed. 11.2 provides the third party with a right to make a representation against the proposed disclosure within 10 days of receiving the notice. The provision expressly mandates the information officer to take into consideration the objections of the third party when making a decision with respect to the disclosure or non-disclosure. It encapsulates the fundamental idea that a party whose personal information is sought to be disclosed is afforded the opportunity to contest to it. Section 1 must be read. Other than in a case where the information applicant seeks disclosure of the which relates to information applicant information sought that falls under personal information. Constitutional right implicated. What happened out here is that the information sought by the respondents pertains to 1, the correspondence and file notings relating to elevation of 3 judges to the Supreme Court. Information relating to declaration of assets made by the judges pursuant to the 1997 resolution and the identity and the nature of disciplinary proceedings instituted against the lawyer and the judge named in the newspaper report. The third referral question requires this court to determine whether the disclosure of the information sought is exempt under J of so and so. In arriving at a determination on whether the information sought is exempt under so and so, it is necessary to determine whether the information sought is personal information and engages the right of privacy. Identify in the facts of the case the specific heads of public interest so and so. determine the justification for restriction such interest, apply the principle of proportionality to ensure truancy. The process under must be complied with truancy. Chalo.
When 19.4 not complied.
Nothing doing. This is
I have
a
not given
case
the
for
right to-
dismissal immediately.
He is not given the right of.
You
hearing.
have got 9 years of freedom. Therefore, the present writ petition has been filed challenging inter alia the order dated 27/5/2014 passed by the respondent number 1 as the second appellate authority under the Right of Information Act 2005, whereby the decision of the first appellate authority under the Act of 2005 dated 15/12/2011 was upheld. It is relevant to take note of that. Next, the facts involved in the instant case is that the respondent number 4 herein had filed an application before the Central Public Information Officer, Office of the Assistant Commissioner of Central Excise, GS Road, Bhangagar, on 1/9/2011, seeking various informations under the provisions of the Right to Information Act 2005. A perusal of the said information so sought for would show that the said information pertains to granting of the eligibility status of the petitioner company under the industrial policy of 1997 and the exemptions to be granted in terms with the Central Excise notification number 33/99 CE and 32 notification number 32/99 CE, both dated 8/7/1999. It further transpires from the above, from the various information so sought for enclosed as Annexure 1 to the writ petition, that such information relates to the granting of the eligibility status, the granting of the eligibility to the petitioner in terms with the said notifications, industrial policy and the notification issued therein under, and the benefits so granted on the basis of orders passed by the public authorities. It reveals from the records that the said information was rejected by the public information officer of the respondent number of public information officer.
On number 3.
That is the respondent number 2. Oh no, respondent number
3.
3. Pusto. Thereupon, the petitioner, the respondent number 4, preferred an appeal before the first appellate authority, that is the respondent number 2. The respondent number 2, by an order dated 15/12/2011, had taken it into account that the information so sought for are in respect to certain actions and orders being passed by the public authorities, which can be revealed under the Right to Information Act 2005, directed the respondent number 3 to provide copies of all documents containing the information sought for by the respondent number 4 within 30 days of the receipt of the said order, subject to the realization of the appropriate fees as laid down in the Right to Information regulation of fee and cost rules 2005. The petitioner herein being aggrieved preferred a second appeal before the court of the before the respondent number 1. And the second appeal was dismissed by an order dated 27/5/2014, thereby affirming the order passed by the first appellate authority. Being aggrieved, the petitioner is before this court under Article 226 of the Constitution. Mr. Adas, appearing on behalf of the petitioner, had submitted that the petitioner herein is entitled to an exemption. No, that the information so sought for cannot be divulged by the authorities concerned in view of the provisions of Section 8D, 81D or 8D,
81D, Your Lordship,
81D
and 81.
of
Then 81E, Your Lordship, public interest.
Huh?
81E also, Your Lordship, public
81,
interest. D and E.
81D and 81E
Larger public.
of the Right to Information Act. Right to Information Act. We have the right to information. Give it. Oh, I got it. 81B and 81E.
Yes, Your Lordship.
And as such, Mr. Adas, the learned counsel appearing on behalf of the petitioner, submits that the respondent, first appellate authority as well as the second appellate authority, did not take into consideration Section 81D and 81E, which were exemptions from disclosure of information. And the case of the petitioner herein falls squarely within the purview of the said provisions. And as such, the first appellate authority as well as the second appellate authority violate the impugned orders or ought not to have divulged the said information or directed directed the respondent number 3 to provide the said information. This court finds it relevant at this stage to take note of that section 8.1 begins with a non-obstinate phrase, inverted comma, notwithstanding anything contained in this act, inverted comma, close. The import of this phrase is that subsection 1 of section 8 carves out an exception to the general obligation to disclose under the Right to Information Act 2005. Where the conditions set out in any of the subclauses in clause 1 of section 8 are satisfied, the information officer is under no obligation to provide information to the applicant. It is further seen that by expressly enumerating the circumstances in which the disclosure of information may be restricted on the grounds of certain identified harm, the RTI Act negates the notion that information may be withheld on the grounds of confidentiality simpliciter. A harm under clause 1 of section 8 must be identified and invoked to justify the non-disclosure of a document requested for under the Right to Information Act. It is also pertinent to note that clauses A, B, C, F, G, and H to subsection 1 of section 8 provide an absolute exemption from the obligation of disclosure under the Right to Information Act 2005. However, clauses D, E, I, J to subclause 1 of section 8 provide a qualified exemption from disclosure. For example, clause A of subsection 1 of section 8 provides an unconditional exemption where it is determined that the disclosure of the information sought would prejudicially affect the sovereignty and integrity of India. On the other hand, while clause D to section 8.1 similarly provides that the information is exempt from disclosure where such disclosure would harm the competitive position of a third party. The exemption, it is further relevant to take note of that the said exemption is further qualified by the phrase, inverted comma, unless the competent authority is satisfied that larger public interest warrants the disclosure. Thus, the exemption under clause D and clause E of subclauses D and clause sub and E of clause 1 of section 8 is not absolute, but is qualified and cannot be invoked where there exists a larger public interest. It is further seen that where the information officer determines that the larger public interest warrants a disclosure, the exemption in clause D and clause E, subclause D and subclause E of clause 1 of section 8 cannot be invoked and the information must be disclosed. We'll come again at 2 to follow it up to dismiss. Ikan di Mahmud. Supplementary लिख दें। It is also relevant to take note of Section 11 of the Right to Information Act 2005. Which relates to disclosure of third-party information. It is pertinent to note that third-party information in terms with Section 11(1) of the said Act of 2005 are information which have been supplied by a third party and has been treated as confidential by that third party. This court further finds it relevant to take note of the judgment of the Constitution Bench in the case of Central Public.
Here's what I found.
Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal. Reported in 2020, 5 SCC 481, wherein at paragraph number 70, the Supreme Court, the Supreme Court in its majority judgment, after making a copious detail of the various earlier pronouncements, observed what comes within the ambit of personal information. The said paragraph being relevant is quoted herein below. In the backdrop of the above, let this court therefore take note of the informations which were sought for by the application dated 1/9/2011. From a perusal of the information so sought for, as enumerated from clauses 1A to 1X, the said informations pertain to public activity except the information so sought for in clause 1G. The information as regards clause 1A, B, C, D, E, F, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X are informations which are in relation to claiming exemption in terms with the industrial policy of 1997 and the notifications issued by the central excise authorities granting exemptions, as well as the exemptions so granted to the petitioner company. By the central excise authorities. Under such circumstances, this court is of the view that there is no infirmity in the order passed by this court by the first appellate authority by the order dated 15/11/2011 in directing the said informations in respect to the information so sought for pertaining sought for in the application dated 1/9/2011 from clauses 1A to 1X except clause 1G. This court further inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner claimed confidentiality in respect to the information pertaining to 1G in respect to furnishing the names of the manufacturers or suppliers of these equipments or machineries, plants available while this court has specifically inquired with the learned counsel for the petitioner as to whether the petitioner claimed confidentiality on furnishing the list of manufacturers or suppliers of the equipments of the machineries or plants before the Central Excise Department. Yes, now tell me.
I don't think so. It is required by the,
No. Did you claim confidentiality when you submitted it?
I don't think so, Your Lordship.
Have you mentioned in your petition that you claim confidentially not to furnish the name to anybody? No.
No, I don't think so, Your Lordship.
The learned counsel submits that he has no instructions in that regard. It is, however, seen it is also relevant to take note of that there is no pleadings also to the effect that confidentiality was claimed at the time of furnishing the information pertaining to the list of manufacturers of the suppliers of the equipments, machineries, plants before the Central Excise Department. Taking into account the above, it is the further opinion of this court that the information sought for under clause 1G of the application dated 1/9/2011 would not come within the ambit of section 11. The learned counsel appearing on behalf of the petitioner further had, before concluding, this court further finds it relevant to take note of another submission of the learned counsel appearing on behalf of the petitioner, which pertains to section 19(4) of the Right to Information Act 2005. Inasmuch as it is a submission of the learned counsel that a reasonable opportunity had to be given to the third party when an appeal is preferred relating to information of third party. The said submission, though at the first blush looks attractive, but the same is misconceived, taking into account that the petitioner herein did not claim confidentiality to come within the ambit of section 11 of the Right to Information Act 2005. In that view of the matter, this court does not find any merits in the writ petition, for which the writ petition stands dismissed. The whole Guwahati Carbon. What happened to the Brahmaputra? Same.
Application date is same year, 1st of September 2011.
Then
The order dated is 28th of May 2014, passed by the second appellate authority. At page
same 1G, 1X. Yes, it is same. এইখনত এইটো নাম কেইটা বদলাব ডেটটো একেই হা আৰু এইকেইটা কোর্ট অর্ডার কেইটা চাইলো দুইটা both dismissed.
oblige, Your Honor.
Yes, take your book or this is mine. In fact, after Subhash Chandra Agarwal's judgment, the Right of Information Act means it becomes very difficult
Yes, Your Honor.
to stop it.
Item number 3,
Oblige, Your Honor. Timing.
The date on 22nd August at 11.
Where is the other side? Yes. The petitioners herein are agreed by the issuance of notices dated 9/4/2018 enclosed as Annexure 3A, 3B, 3C, 3D, 3E, 3F, 3G, 3H. On the ground that the said notices were issued and the petitioners were directed to close down their cow shed without providing any opportunity of hearing to the petitioners. Mr. Appearing on behalf of the respondent number 5, 6, and 7.
No, my lord, he is the petitioner, my lord. He is the petitioner.
You.
My lord,
That is the problem. Yes, your name.
My lord, M. Smith.
So and so, appearing on behalf of the respondent number 5, 6, and 7, submits that they were the complainants at whose behest the GMC authority had taken the action. It is the specific case of the respondent numbers 5, 6, and 7 that they are the residents nearby the cow sheds maintained by the petitioner, run by cow sheds maintained by the petitioners. And as the cow sheds have been maintained in a unhygienic and
Unhygienic situation, unhygienic state of. In a
in an
residential area.
unhygienic condition, the same is affecting the said respondents as well as the nearby residents. Upon hearing the Mr. S. Bora appearing on behalf of the GMC submits that taking into account that there was no hearing granted to the petitioners before passing of the impugned notices, before issuance of the impugned notices dated 9/4/2018, the GMC authority would pass appropriate orders after hearing both the petitioners as well as the respondents, private respondents, prior to passing and thereupon pass appropriate orders as deemed fit, taking into account the provisions of law. Mr. S. Bora further submits that who will hear it? That further submits upon instructions that the Commissioner, Guwahati Municipal Corporation, shall hear both the petitioners as well as the private respondents on 22nd of August 2023 at 11 a.m. in his office. At At the commissioner, in the off, in the office of the corporation at Bhangagar. Full stop. Taking into account that the impugned notices dated 9/4/2018 enclosed as Annexure A, B, C, D, HLK were issued without hearing the parties, petitioners. This court, on the ground of violation of the principles of natural justice, sets aside the said impugned notices dated so and so. Full stop. This court further, taking into account the submission of Mr. S. Bora, directs the petitioners, if so advised, to appear before the commissioner of GMC on 22nd of August 2023 at 11 a.m. in the office of the GMC at Bhangagar, and directs the petitioners as well as the respondent, private respondents, to appear. And the commissioner GMC shall thereupon, after hearing the parties, shall pass appropriate orders in that regard. Full stop. The petitioners as well as the respondent, private respondents would be at liberty to submit their statements, written statements, if so advised in that regard. With the above, the petition stands disposed.
My lord, one more thing, my lord, liberty may be granted to the other people residing in the vicinity to appear in the meeting, my lord. Their complainants.
You get hold of those people and take them.
My lord, when liberty, otherwise they will not be allowed to enter the office, my lord. The other, their complaints, more than 11 complainants were there in the complaint, my lord.
No, I am not allowing other people. This is the you three are there. I think three will do, and then you show the commissioner, look here, those people are standing outside. Yes. I stands close in view of this.
Item 42 and 43.
I could contact the petitioner of item number 42. So for 43, I could not contact. My lord, I advise him not to withdraw. But my lord, his apprehension is that, my lord, if it is dismissed, then he may suffer. That is his contention. So my lord, can it be taken up on Monday so that we can advise him not to withdraw? So on Monday, it may be taken up.
Don't worry, we dismiss it.
But that
What
is-
are you asking for? Let us see
Fine.
this.
Page 97 is the communication, page 97 and exact 25.
You are challenging the complaint.
No, complaint was filed.
Yes, it is there. I read in the
Yes.
certiorari should not be issued directing and quashing the impugned complaint
Hmm.
filed by the respondent number 5 registered as complaint
Fine.
case number.
The complaint was filed and it is against a government servant and it is a private complaint and it was filed before the special court. Then that complaint was referred under sections 200 in exercising power under 156 of the CRPC to register a case. It was sent to the CM Vigilance to register a case and investigate the matter. Now, then they investigated the matter. So for the accused is concerned, there was nothing was found against him, but the petitioner was implicated in this case. Now, yeah, we are here, my lord, hampering that whether a complaint can be referred under section 156 CRPC, my lord, without any sanction, government sanction, because the officer are government officer. That is the issue. My
Why is it required?
Section 19 of the Prevention of Corruption Act is specifically stated that sanction is required
For
for sending the to take cognizance of that complaint. That is the
Huh?
PCI
prevention of corruption.
and even CRPC 197.
197 is for trial.
190.
We are not concerned with
Right.
trial. 156(3) comes at a stage even prior to trial, not
Right.
trial, before registration.
Before.
156(3) is only for investigation purpose.
Yes, yes, yes.
So 156(3) had no relation whatsoever.
In a complaint case, whether it is required or not, that
No, it can't be, the court has not treated it to be a complaint. If he has exercised the power under 156(3) and directed for investigation. So the court did not exercise the power under 200.
not. But on this similar issue, the Supreme Court, my lord,
Huh?
on similar issue,
Huh.
have annexed that judgment also page 99.
Yes, where?
Page 99.
No, first let us see section
Oh, section.
19, which required. 197 not required. Then previous saying for prosecution.
Right.
No court shall take cognizance of an offence punishable under section Iman to have been committed by a public servant except with the previous sanction. Where is it required?
Right.
Cognizance will come under 200. Isn't it?
But wonderful,
They may file a charge sheet under 173.
Right.
And thereupon the cognizance will follow.
that is the difference when possibly that Supreme Court laid down.
What did they say?
My page 99 for him,
Page
99. I have annexed that judgment.
29. Huh? Page 29, which
19
matter?
99. 99.
Oh, 9. Yes.
My lord, if you lordship see page 113, that last paragraph 13.
There is the content that the requirement is also is only procedural in sanction directly and externally and there is. Find the section 13 has an object which applies in found where special judge has already handled the findings. Shall not be reversed or by court. Once it is different, there is no previous sanction.
There are also one public, public.
Show me that Parasnath judgment, Parasnath.
That I have not, my lord.
Yeah. Got it. And the jurisdiction of a magistrate to take cognizance of an offence is provided under 190 of the Iman either on receipt of a complaint or upon the police report or information received pursuant. So far as the public servant to under the cognizance of any offence is barred by its unless sanction is obtained and the offence alleged to have been committed was in the charge of official duty. The section does not specify to whom the protection but it also provides the conditions of mandatory consent of jurisdiction. Audit to the protection of the community. Yes, with due respect to the Supreme Court, where did the Supreme Court find 156(3)
My
in
lord.
Parasnath judgment?
I have no details that been, my lord. That
No, here,
My-
you see what the Supreme Court did in the last year. Cannot order investigation against the public servant while invoking the powers under section 156(3). The above legal provision, as it already indicated, have been clearly spelled out in Parasnath and Subramaniam Swamy. Now, where is it mentioned out there? When a solicitor refers a complaint for investigation, obviously he has not taken cognizance and therefore it is freeholder and cannot be equated with. When solicitor takes cognizance. Now, kindly see here, paragraph 10.
Right.
The meaning of the expression was also considered by this court in Subramanian. The judgment referred to herein above clearly indicated that word cognizance has a wider connotation and not merely confined at the stage of taking cognizance. Where a special judge refers a complaint for investigation, obviously, he has not taken cognizance of the offense and therefore it is a pre-cognizance stage and cannot be equated with a post-cognizance stage.
Right.
When a special judge takes a cognizance of an offense on a complaint presented here, and the next step is to follow is under section 202. Consequently, a special judge referring the case for investigation is at a pre-cognizance stage.
Our question is that on pre-cognizance stage also, my lord, the sanction is required or not? That
A
is,
magistrate who is otherwise competent to corner without taking corner may direct so and so. The magistrate who is empowered to take corner alone has the power to make. See this paragraph 11 again.
Right.
A special judge is deemed to be a magistrate under section 5(4) of the Act and therefore clothed with all the magistrate powers. When a private complaint is filed before the magistrate, he has two options. He may take cognizance of the offense under section 190 or proceed further for inquiry or trial. A magistrate who is otherwise competent to take cognizance without taking cognizance under SWAM may direct an investigation under section 156(3). The magistrate who is empowered under 190 to take it alone has the power to refer a hearing. We may now examine as to the requirement of the people for ordering investigation.
that's 12.
Where in the earlier judgments this is given? Difficult? Let us see what has happened to this judgment thereafter. Yes, so that is your point. Tell me. Huh? Who appears? Where is he? He will not come. Let me deliver the judgment, then let him come. Call him. Hello, next video. I'll take it. Both the matters are same.
Same.
9.
In fact, that specific issue came up in L. Narayana Swamy versus State of Karnataka. 2016, 9 SEC 598. Yes.
9.
You are the claimant. Who has filed this petition? For what? Hmm. Where is the PWD? Not appearing. Is there a stay? Have you got the money?
No, not.
What is the ground on which it has been done? For? Let us see the order, permanent look adalats. Page 27, yeah. In brief, the first party is that demand at about demand, a right of elocution due to leakage of current.
Sorry, I'm a petitioner.
Yes.
Well, here an award is a challenge.
Hmm.
At the onset, my lord, this was filed with the earlier set of standing counsel for the PHE. And what my anxiety is this, my lord. I have come across a few orders and also, my lord, in unit section article 300, my lord. This person executing this petition is not maintainable, my lord. I'm quoting this.
Because it has to be done through the,
State, my lord. It is his, he has come in his official capacity, but award was against the department, my lord. I'm just passing on, my lord.
but you need to pay this amount.
Yes, ma'am. And
He's asking, he died out of 17 lakh 50,000, he got 1 lakh 75,000.
there was one question that there was no civil suit. There has to be a parent civil, lordship, page 15. This has been discussed, this aspect has been looked into.
Page,
Page, it's 6, internal page 6, para 15. Starts with as discussed about.
but you submitted yourself to the jurisdiction.
But that point was raised in that point. So, my lord.
But then, you see, there was a matter filed before the permanent local,
Yes,
where you were a party.
yes, ma'am.
You participated in the said proceedings.
Yes.
You submit your written statement.
Written statement therein, my lord.
Where is it?
Jurisdiction or challenge, my lord. Page 27, bottom part, my lord.
No, you have not challenged the jurisdiction.
There is a whisper, my lord, at page 27,
Yeah.
bottom part, my lord.
What?
The second party denied all allegation challenges jurisdiction by filing WS.
You see the written statement at page 23. Where is the jurisdiction challenge?
My lord.
No, it is not there.
Well, better, my lord, this is heading for a dismissal, to be very frank.
Huh?
There was a subtle point, my lord, but the method of approach was wrong.
And this particular permanent local adalat is where?
It's in my lord
How do
Karimganj.
you file it? It is under the Legal Service Authority Act.
Yes, my lord.
How you call Legal Service Authority Act?
There was a question, my lord, there has to be, in my understanding, there has to be a parent suit. If in that suit, it has to be relegated to the local adalat to adjudicate.
Legal Service Authority. Yes. Okay. No. Yes, any party to a dispute may, before the dispute is brought before any court, make an application to the permanent local adalat for settlement of the dispute.
Right.
So therefore, the jurisdiction is there. And public utility service has been brought within the ambit of this under 22B. Means transport service, post, telegraph, water, supply of power, light, water, public by so and so. It comes in.
There also apartment of this,
No, this has to be totally dismissed, not on the ground, because tomorrow again you will come.
we won't come, my lord.
No, you are
Because
not paying
see,
for
this
the
is-
last so and so
Well,
now.
This is a 15 matter, my lord, we are not there that time.
Not necessarily. The instant writ petition has been filed challenging the award dated 23/12/2014 passed by the permanent local adalat at Karimganj in PLA case number 2/2013, whereby whereby the second party in the said proceedings that is the petitioner number 1 and 2 along with the state of Assam were directed to pay an amount of rupees 1,75,000 within 3 months from the date of the said award. The instant writ petition, however, now, Gustav, subsequent to it is relevant to take note of. That all the parties who suffered the said award did not approach this court except the petitioner number 1 and 2. Good stop. From a perusal of the writ petition, the only ground so taken is that the permanent Lok Adalat at Karimganj had no jurisdiction in PLA case number to award the compensation in PLA case number 02/2013. This court, for the purpose of this court, finds it relevant at this stage to take note of the Legal Services Authorities (Bracket Amendment Act 2002), wherein Section 22C stipulates the cognizance of cases by the permanent Lok Adalat. From a perusal of subsection 1 of Section 22C of the Legal Services Authorities Act 1987, as brought into effect by the Amending Act of 2002, any party to a dispute may, before the dispute is brought before any court, make an application to the permanent Lok Adalat for settlement of the dispute. It is further seen from subsection 8 of Section 22C that where the parties fail to reach an agreement under subsection 7, the permanent Lok Adalat shall, if the dispute does not relate to any offense, decide the dispute. Therefore, taking into account subsection 1 and subsection 8 of Section 22C of the Legal Services Authority Act 1987, this court is of the opinion that the permanent Lok Adalat had the jurisdiction to pass the award dated 23/12/2014 in PLA case number 02/2013. Next. This court further finds it relevant to take note of that it is the assistant executive engineer as well as the executive engineer, public health engineering, who have filed the instant writ petition. Surprisingly, the public health department, represented by its commissioner and secretary, did not assail the award dated 23/12/2014 passed in PLA case number 02/2013. Taking into account that the award was not personal to the said petitioners, but was a liability upon the said department, it is the department who ought to have approached this court. On that ground also, the instant writ petition is not maintainable. In that view of the matter, the instant writ petition fails and accordingly stands dismissed. The petitioner shall be at liberty to take appropriate steps before the authorities, before the appropriate forum, for the purpose of realization of the amount, for the purpose of recovery, for the purpose of execution of the award impugned in the instant proceedings.
All right.
Records so and so. So brought on record, and the records here is.
Give the list.
Records are, no. The registry is forthwith directed to return the records. LC.
10,
It is a rush. Herein I challenge an order of eviction, my lord, issued by the estate officer of NF Railway Lumding. On the last date, my lord, the NF Railway Lumding, they disputed the fact that our claim that we said that no show cause
Where is that order 1812?
page 25, my lord.
Page 25.
Whereas I, the undersigned, am satisfied for the reasons recorded
Yes,
below.
tell me. Why have you approached this court?
My lord, because I challenge the jurisdiction itself of the estate officer seeking eviction as it is claiming to be a public premises, whereas this land was allotted to me by the government and I have been there since 1970-71.
So if the land has been allotted to you by the government, why haven't you placed the materials before the authority?
They have to give me show cause for that, which
They have not issued show cause.
No, they say that they issued, but it was not given to me, and they have even in their affidavit in opposition, they do not say so. That's my precise case, my lord. If they would have given me a show cause notice, I would have appeared and submitted.
Yes, madam, did you produce the issue the show cause?
My lord, estate officer has to say.
Without filing the appeal. Huh? By the Hanuman Mandir, it should quickly was allotted to the railways prior to the construction of Hanuman Mandir. Roughly 12 and 12. Where have you stated no show cause?
Myself, my lord,
Notice was served by letter dated for evacuation of the granting sufficient time. As per observation. Who is appearing for the state respondent, estate officer? Fantastic. Now tell me, did you issue the notice? Huh? Where is that notice? Was the notice received? Because here you say in your order that at the time of hearing on 16/2/2012, but no satisfactory reply as well as convincing documents could be produced. Meaning, did they submit a reply?
They appear before the officer.
Right?
let them produce the records, my lord. Then I have. In fact, in the affidavit in opposition in paragraph 13, they say accordingly notice was served by letter dated 18 December 2015. This is the final order which they are calling it a notice.
No, but depend on 1/11/2011.
You see, for secretary, some Premchand Jha has received
On behalf of the
Madan Singh, Meher Yadav or something. Then eviction case to the secretary so and so on 16/2. Then you have received.
My lord, this I'll have to take instruction, but what?
Don't take instruction, I dismiss it
My
now.
lord, not kindly dismiss it.
No,
my
no,
lord,
no, no,
because
no, madam,
this is a different
nothing
proceeding.
doing.
This is a-
These are not matters to be
This is-
taken. Why haven't you filed an appeal?
My lord, this is a different proceeding, my lord.
Maybe.
The page that he.
I give you 15 days, file an appeal. Or not 15 days, 12 days.
My lord, I will just.
12 days,
My lord, I will do it.
12 days,
7
nothing doing.
days I will do it, but my lord, no, kindly just. If
Nothing
I'm
doing.
unable to satisfy,
No, 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 these are not cases to be taken up out here. Go there. Why? What is this? You have come out here, issued notice and got a stay out here.
my
What is
lord.
this? These are
my
public
lord,
lands.
My lord, the state government has regularized that in 2015.
Understood.
after-
Why haven't you submitted anything, any documents out there?
My lord, in 2012, this is a different proceeding letter they have produced, my lord.
Why?
This is not, in the notice they said in 24 January 2012, they have given notice and they are producing.
What
something of-
24 January? This is on 1/11/2011.
Not to this proceeding.
Huh?
This is not with respect to this proceeding.
Why?
My
See,
lord,
see the order?
page 25.
No, kindly see page 25,
If you
notice
put-
dated.
If you notice dated 24th January 2000.
What 24th January? The page 25 is 1/11/2011. Why you are saying this?
Because I-
Asking you to submit the so cause on
I got this
24/1.
letter just now from him. He did not even put it with the.
Not necessary.
written
We are dismissing it. Enough.
My lord will not dismiss it. I will file an appeal, my lord.
No, that is better.
That I will do, my lord. But jurisdiction question of, I'm not submitting to the jurisdiction, my lord,
Why?
because that land is not railway land. Even the state government has said it.
So,
My lord, they are the estate officer,
madam,
proceeded.
there are many judgments of the Supreme Court also,
my lord.
wherein it states that the moment there is a bona fide dispute, the estate officer cannot adjudicate the dispute. Then they have to resort to something else.
My lord.
So unless you bring the dispute out there, how do you take care of it?
My lord, correct, my lord.
Then
I will do that. My 2 weeks time may be granted, my lord.
not 2 weeks,
10 days.
12 days. Where's that? The public premises, where is it? Mr. Council, where's the Public Premises Act? 1971? See, how much time? 12 days or 9 days or 8 days, something like that. I can't give you more than that.
My lord, it's all right.
How much?
Okay, 10 days.
No. See,
Oh,
the
that-
mandate,
that let me find out, my lord.
12 days? 12 days. I remember that.
Oh, the-
The instant writ petition has been filed challenging the order dated 18/12/2015 passed by the estate officer NF Railway Lamding under the provisions of section 5(1) of the Public Premises Eviction of Unauthorized Occupants Act 1971. Full stop.
Yes, not earlier than 7 days. The time can be granted.
No, not
It's
that
all right,
one.
It's all right, my.
The appeal is
my
before
lord,
the
my
district
grant
judge.
me
Where is it?
this time, my.
Yes, appeal. It says, yeah, in case of an appeal from an order under 5B or within 12 days, in case of area 5(1), in case of an appeal under so and so, on date of publication of AR 12 days, within 12 days. Full stop. The case of the petitioner herein is that the land in question was allotted to the petitioner. By the government of Assam. And in that regard, have placed on record a Jamabandi for the surveyed village pertaining to Dag number 472/1531 of Patta number 1241. From a perusal of the said Jamabandi for the surveyed village, it reveals that on 14th of May 2010, the said land was regularized in favor of the Hanuman Mandir. Oh. The DC couldn't have done it. The DC was doing all these things. Ah.
They do not say in the affidavit could not have done it. They say that it should have been, they should, subject to approval by the government, but they do not also say that approval was taken or not taken. I have a copy in case I can share my copy.
Madam, I have delivered a judgment on that Nagaland issue, na? Where there was in Dimapur that huge problem was there. There was all this, the deputy commissioner was, as the ADC was right, left and center, giving it to everybody. Oh. Anyways. The railways have also filed an affidavit wherein it has been mentioned that the Hanuman Mandir is situated, that the land on which wherein the Hanuman Mandir is situated was allotted to the railways prior to construction of the Hanuman Mandir. That is, in as much as the land was allotted to the railways in the year 1963,
My lord, for this they could not.
and the
place any-
Hanuman Mandir was constructed in the year 1970-71.
They have not placed any record to that effect, ma'am.
It has been further mentioned that the proceedings under the Public Premises Eviction of Unauthorized Occupants Act 1971 against the petitioner was carried out by following the due formalities and by issuing notice to the petitioner, which was duly received on 4/11/2011. And having not found the satisfactory reply, the order, impugn order dated 18/12 or what?
Yes.
18/12/2005 was issued. 15 was issued. Miss. Yes, madam, where's your affidavit? Okay, give me a copy. Anyway.
They are not disputing this fact, my lord, that it was allotted.
Miss M. Kichi, what is your name? Yes. The learned counsel appearing on behalf of the state of Nagaland has drawn the attention of the affidavit in opposition filed by the respondent number 4. Wherein, amongst others, have stated that at the time of regularizing the land in favor of the petitioner, on 14th of May 2010, there was a complete ban on transfer or on settlement or allotment of land except upon approval of the state government. That is what, except upon approval of the state government. Full stop. She further submitted that the DC order number REV-91D- bracket part 1 bracket close 1966-700 dated 14/4/2010 is silent as to whether confirmation or prior approval had been taken from the state government. Full stop. From the, full stop. Yes, madam, now tell me, what did you want to say?
My lord, here from the affidavit filed by the state government, my lord, this is clear that it was not allotted to the railways. That is why I don't want to subject myself to the jurisdiction of.
On the other hand, Ms. B. Goyal, appearing on behalf of the petitioner, submitted that there is no materials that the land in question was allotted to the railways in the year 1963 or at any point of time. And as such, the exercise of authority by the estate officer under the Act of 1971 treating the said land to be a public premises was erroneous. Full stop. Upon hearing the parties, it appears that there are serious disputes as to whether the petitioner have been allotted the land in accordance with law, and further as to whether the railways are the settlement holders of the land in question. Taking into account the above, and also further taking into account the above, the said aspect to the matter, and also Section 9 of the Act of 1971, it is the opinion of this court that such facts can be adjudicated upon by the appellate authority, that is the district judge where Dimapur.
If it is this, I do not know. So far as the estate officer is, the order impugn is from Lamding.
No, where is the land?
Dimapur, Dimapur.
Dimapur. By the district judge. Dimapur.
My lord,
Dimapur is a district,
yes.
but the district judge Dimapur. Full stop. Taking into account the above, this court therefore is not inclined to interfere with the order dated 18/12/2015 passed by the estate officer NF Railway, Lamding. Full stop. The petitioner, no, full stop, and accordingly dismisses the instant petition. Full stop. And is not inclined to interfere with the order dated 18/12/2015. Full stop. This court, however, grants liberty to the petitioner to prepare an appeal under section 9 of the Act of 1971. Full stop. If the said appeal is preferred within 12 days from the date of the instant order, the appellate authority, that is the district judge Dimapur, shall not dismiss the said appeal on the grounds of limitation. The interim order so passed earlier by this court shall remain operational till today is what date? 4/12. 17th. 12 days is 17th.
17
1, 2,
plus
3,
certified
4,
copy, my lord.
5, 6, 7, 8, 9, 10, 11, 12. Till 17th of August
plus
2020.
plus certified copy, my lord, plus certified copy, because now it's past 3 o'clock, my application will not be submitted for certified copy.
That is why one more day is being given to you. It completes otherwise on 16th.
I'm grateful, ma'am. I'm so grateful.
But I can't extend more than that. You'll get the certified copy tomorrow. Sure. Take this. You see this judgment? I'm giving you the list of judgments. Two 10 SCC 705. 2014 1 SCC criminal 2013 10 SCC 705. 2012 10 SCC 517 and 2016 9 SCC 598. 2016 9 SCC 598, a specific question was framed wherein it says there were 3 questions framed. The first question is whether an order directing further investigation under section 156(3) of the CRPC can be passed in relation to a public servant in absence of a valid sanction and contrary to the judgments of this court in Anil Kumar versus Ayappa and so versus so. And it was answered, no. So if you have any further judgments from there, matter have been heard extensively, it would be heard tomorrow at 2 p.m.
Item 11.
Wait, please, Lord.
Yes.
My lord, in this petition, my lord, the petitioner is the co-portrator, man. And the land of the petitioners along the, my lord, co-portrators were acquisition by the authority for extension of 4 lane, my lord,
Where acquisition by whom?
by the National Highway Authority. While sending the proposal, the names of the petitioner, my lord, was dropped, my lord. Accordingly, petitioner has filed a representation before the Deputy Commissioner Shivsagar, page 16, my lord. And there was not disposed of, nor, my lord, the names of the petitioner were forwarded for payment of compact. This is the simple thing.
This is land acquisition done under what provision?
My lord, by the Highway authority, my lord, it was done, my lord.
Highway? National highway?
National
was
highway,
that?
yes.
Then why did you?
My only grievance is
No,
with
no,
my neighbor.
no, nothing doing. First and foremost, tell me, who has done the acquisition?
The revenue authority.
No, revenue authority. You don't know under what provision it has been acquired. What? What authority?
It's the revenue authority, district revenue authority, my lord.
See, if it is done for the national highway, it will be done under the 56 Act. If it is done by the state, they may do under the Land Acquisition Act of 1894, if that was there, or the 2013, or under the 64. Which one?
That I have to take.
What?
That I have to take instruction.
You want an instruction of a matter pertaining to 2016 in 2023. And isn't that the crux of the issue?
Yes.
Because if it is done under the National Highways Act, it will, the competent authority has to be notified under Section 3. And you have to approach him. And if it is the deputy commissioner you have approached, it has to be either under the 64 or the, what do you call that? Because it has to be done within a period of 6 months. When did you approach? It is a case of apportionment.
Yes.
Then when did you
Not
approach? Where is your representation?
Not apportionment, my lord.
Why?
My prayer is, my lord, my name was not forwarded, although the co-portfolio's name has been forwarded. This is
Understood. So you are entitled to compensation.
Yes.
That means you are entitled to a portion of the amount. So it is a case of apportionment falling under Section 18(1). Then where is your inclusion?
my petition, my lord, page 16.
Representation is where?
Page 16.
Written to whom?
It was my lord, forwarded to deputy.
With due
commissioner.
respect, I beg to know below that when to buy that for 4-lane highway. My name has not been included in this getting only for which I am deprived of it. Therefore, we to remeasure the scheduled land for inclusion of my name in. Yes, whether any award passed.
Also, before going deep into the merit of the case, one thing I have come to know from the inspector, that we decide no loan from the provider. Yes, expired 3 years,
That people,
and then that about the fee report to speak for the rest, but the report, circle officer report says that the land for which maybe compensated is no longer in possession of that particular land belongs to another person who happens to be the co-partner by lineage of other.
this is done under what provision? You know everything except that. What provision? Acquisition under what?
So that particular act, that part is not clear. But what?
Have you passed an award?
Yes, that award has been passed.
When?
That award has been passed.
Mr. S. Bolwa, appearing on behalf of the respondent, submits that the petitioner had expired. Mr. P.J. Saikia, learned counsel, appearing on behalf of the petitioner, states that he has no instruction in the matter in respect to the matter. He therefore submits that a week's time may be granted for that. List the matter again on 11th August.
Double.
Get your instruction whether should we proceed against the dead person.
13,
Yes, anything? Mr. Bolwa?
this is the order. Non-compliance, another complaint. Finally, sort of compliance has. So now here was the care of Villa. Claiming that the land that.
Then
After
I come page 34. With due respect, I beg to state that a scheduled land is acquiring land for a construction area for payment of compensation, and Jirat has submitted the necessary affidavit and no objection. Then the petition somebody else has given. And so and so. In them, he has also given. Application for not pay the compensation in respect to my plot of land. So and so. Then petition filed. Let the representative be disposed of as expeditiously as possible. Contempt file, contempt and from the representation, a report from the surveyor was called, the circle of the conductor of the trial submitted so and so was in possession of so and so, son of so and so, demand and had purchased the land from so and so on demand by registered vehicle. Land was included in the legal. That on demand order was passed by government. And to the order if it increases to execute and demand to be done for hearing regarding people. Hearing of the party.
going to record page 59. The report which has been submitted by the last month. So here, guys, the board verification report that has been done. Also, with three because 3 letters of land. That's because also, three land 2 because 80 letters has been acquired for the purpose of gateway line. A part of the state and 70 of Virat is submitted earlier. So by mistake, that was reported in to Kata of land in the
None appears on behalf of the petitioner on call. On the last occasion also, the petitioner was not represented. Taking into account the above, it seems that the petitioner is not interested in the matter for which the petition stands dismissed for non-prosecution.
1450.
Yes, madam.
For non-payment of, for not refunding of security deposit amount,
Non-payment of,
not refunding security deposit amount.
yes, security deposit. Why not return? Oh, you are there for finance. No affidavit filed.
In affidavit file in, second, this affidavit file.
Hmm?
In second case affidavit file,
What is the ground?
they deposited before the income tax office and income tax office has not been done in the same.
What is the second petition?
Against who work order?
Now, why the refund has not been given in the second one?
Same, way they have deposited on the account of VAT, my lord.
Yes, yes. Why you have not given the refund?
Money is in the lordship tax.
Money is,
The tax department.
how does the security deposit go to the tax department?
Kindly see, my opinion,
Yes, what is it?
file with the. Page 2, paragraph 2.
Huh.
It is in the March 2013, an amount of 11 lakh 2012 was realized from different perspectives as well. But due to extreme large payment during the state period, the amount of debt realized was deposited to the state department twice due to our side. Soon after such incident, the matter was communicated to the tax authority.
So your thing is that you have given the money to them and they are not refunding, for which you are not being able. Yes, you are there. Finance department?
Not a particular,
No, you do whatever it is. You pay him.
the basket on
No, we are not. It is your fault. It is your fault they have not got it. Who has asked you to deposit it twice? Huh? Now, who is going to pay the interest? You are entitled to interest on security deposit. What is the percentage? 10, 12, 15?
there are a number of communication with the tax department.
Understood. Your tax department doesn't want to do it. That is your lookout. But this is the, upon completion, she is entitled to the refund of the security deposit. And that you admit. Then deposit, give it to them. How much interest? You didn't expect it.
There is no such prayer for the menor.
In the other case also, it's the same.
Same.
Hello, এটা মই dictation দি দিছো, এইটো কৰি দিম। The petitioner herein is aggrieved on account of the non-refund of the security deposit amount of rupees 4,46,439 to the petitioner by the respondent irrigation department. And as such has filed the instant writ petition. The brief facts of the instant case is that the petitioner was issued a formal work order on 9/3/2013 for the various works stated in the said work order. In terms with the said work order, the time of completion was 20 days. And the value of the contract was 55,80,491. It further appears from the writ petition that the petitioner also deposited 2% of the total amount as security deposit. Good stop. The petitioner completed the work to the satisfaction of the respondent irrigation department and received the entire dues towards the contract, towards the performance of the contract. However, the security deposit which was security deposit of an amount of rupees 4,46,439 was not refunded. The petitioner on various occasions represented before the respondent authorities. But the said respondent authorities did not take any steps for refunding the said amount for which the instant writ petition has been filed. It appears from the records that this court had issued notice on 2/8/2019 . It is further relevant to take note of that there were certain orders also passed by this court directing the respondent authorities, respondent irrigation department to take steps for expediting the payment refund of the said amount. It further reveals from the records that an affidavit in opposition had been filed by the respondents, wherein it is the specific stand taken that the respondent irrigation department inadvertently deposited rupees 11,75,041 realized from different contractors as VAT twice. And they have been pursuing with the tax authorities but the tax authorities have not refunded the said amount for which the respondent irrigation department is not in a position to refund the said amount to the petitioner. Next. Upon hearing the learned counsels for the parties, it is clear that there is a clear admission on the part of the respondent authorities that they are liable to pay an amount of they are liable to refund the amount of rupees 4,46,439 to the petitioner. Which were the security deposits deposited by the security deposit, which was submitted by the petitioner at the time of entering into the contract. the difficulties faced by the irrigation department for not being able to get out the money, or for not being able to get the refund from the taxation department of the government of Assam, in the opinion of this court, cannot be a reason to withhold the said amount to which the petitioner is entitled to. Under such circumstances, this court therefore disposes of the incident with petition with a direction to the Secretary to the Government of Assam Irrigation Department to take appropriate steps for refund of the said money, said amount of rupees 4,46,439 to the petitioner within a period of 6 weeks from the date a certified copy is submitted before the Secretary to the Government of Assam Irrigation Department. So it is made clear, if the said amount is not paid within a period of 6 weeks, as mentioned here in above, interest shall accrue at the rate of 12%, which shall be deducted from the salary of the Secretary. Then only payments come. It is made clear, if the amount is not refunded to the petitioner within the period of 6 weeks, 3 months, 3 weeks. 3 weeks? 6 weeks. 6 weeks. The respondent irrigation department shall be liable to pay interest, which this court quantifies it at the rate of 9% from the date of such default.
Milord, in petition amount is different and work order date is different.
এটো বদলাই দিব এটো এনেকুৱা হ'ব এটো ভালেই খালি ইয়াত হল এফিডেভিট নাই ফাইল কৰা বাট ইয়াত এখেতে কৈছে বুলি কৈছে he says Upadhyay. And Mr. Gogoi, why were you appearing? That at a line lekhok. That at a line lekhok. He is appearing. Mr. B. Gogoi, the learned counsel, who also is the standing counsel for the Finance and Taxation Department of the Government of Assam, shall also instruct the taxation, the Secretary to the Government of Assam Taxation Department, Finance and Taxation Department, shall also instruct the Commissioner of Taxes of the Taxes, Assam, to do the needful upon request being made by the Irrigation Department for the refund of the said amount. I think this will help you.
16.
Yes, Mr. Mahato.
My lord. Can it be taken up some other day, my lord?
Okay.
Non-payment of my lord advocate bills, my lord. Professional fees, my lord.
Advocates bill and they are filing writ petitions.
My lord, there's a petition. And that, in fact, my lord, they say the sum of amount they have been paid, so I have to verify. Not for me, my lord, it is from the hospital.
You have verified how much he is entitled to? Which department? When? Levy it on 21st. Pay that amount. Process you have already, this requisition is of the year 2018.
my lord.
The process must have started when Mr. Mohanto appeared.
Actually, I am not appearing this, my lord. Mr. PP, the is not here today. Anyway, my lord, I am not on that, my lord. Your lordship kindly see, my lord, the bill which was submitted by that senior council. And it is quite reasonable, but from their point of view, they have, my lord, per case, they have giving 20,000 rupees. But he claim in fact 6,000 rupees per day as a senior council. And that, my lord, your lordship kindly pays 14, my lord, of the writ petition, my lord. Just now I have seen, my lord. It's not, my lord. It's a quite as per the government rate, my lord.
Then go before the trial court.
And that's true, my lord.
Whether that rate is good or bad, it is dependent. Fees is perspective.
So now, my lord, he says that yes, some amount has been paid. So I have to verify, my lord, what is taking.
Mr. D. Nath may be very considerate to his client, may not be charging much, whereas Mr. Mohanto may be charging a lot. You never know.
So let it be. I'll take instruction, my lord. So what he has, my lord.
For you, this is very considerate. For others, it may not be.
My lord.
So
Absolutely.
it is
that's
very
correct.
perspective.
That's correct, my lord.
And for the government, it is maybe too high.
And today, just now, he has given me this, my lord. I have to, my lord, convey to my client, my lord. It will be after a week, my lord.
So as per you, another 31,000 left. And if you are not agreeable, go file civil suit. We'll have it on 28th of August. Get your instruction of clearing this 31,500. List the matter again on 28th of August 2023, on which date Mr. D. Nath, appearing on behalf of the respondent, shall apprise this court as to whether the amount of rupees 31,500 has also, which is the remaining amount as per the respondents, have been disbursed to the petition.
Must be.
Yes. Why the matter is so big, Mr. Dubey? To create a fear psychosis upon the judge.
My lord, it has run its course, my lord. Come short by virtue of my lord, elapse of time. Lapse of time.
Success.
So one issue remains, my lord.
There you see. What is the issue?
My lord, on which my lord, my learned friend was to take instructions as regard the eligibility of the director to, my lord, the election has been, my lord, not approved by the register on 25/5/2018, my lord. Period of 5 years has already elapsed. But there is a provision, my lord, if it's the section 41, my lord, if the elections are not hold, my lord, well, the 37 also, my lord, he becomes ineligible to be elected for the night. But in this case, my lord, it was basically a nomination by which the election was conducted. Nobody has come forward, my lord. And was the managing director, my lord, has prepared the list, my lord, there was anomaly of only one single vote, my lord, and that too, he did not have a right to vote. So in effect, my lord, there could not have been any change in the voting. Otherwise also, my lord, the election did not take place. And the complaint was lodged by some of the members, my lord, who were not in existence or somebody who had already expired, my lord. And thereafter, my lord, one-man committee was formed, my lord. He is still running the show, my lord. And it's in the interest of. Come now, return.
Yes. You are challenging an order of 31/7/2018, 25/5/2018 of a proceedings of an AGM. What remains?
The only thing, Lord, if elections are to be held, Lord, they should not be held ineligible for participation in that. So that much. But this instruction was sought, Lord, and they did not, Lord, on the other.
Yes,
Lord.
what is your instruction? 37.
40.
Oh, that's 40 years.
Four. Clause 8. Clause 40.
Not conducting or wrongfully conducting annual general meeting under 39 or so and so, so and so. So 44A.
Clause 54, clause 4. The period of 5 years as clerk from the date of such member be directed for. So when 5 years have come, but that disqualification by the
Goes.
So
that-
5 years have come.
So nothing remains. So I'll record it.
Yes, well, record. Well, there is an inquiry.
It has been-
Indicated.
It has been submitted at the bar that the instant writ petition has become infructuous. Who are you? Yes. Yes. So the board of directors have not thought about the period. Yes. Where, para? Yes. It is observed that who are you? Ganesh Chandra Rahong? No, are you Ganesh Chandra Rahong? So how this observation will have any impact upon you? Then? Why? Now, let us assume they have not done. Then does the act for stop them under section 40? 37? Disqualification of members of the board and administrative committee. So how does this thing that they not taking any action would amount to acting prejudicially? Have you filed an application before any authority for the purpose that why they are not taking any action, or the registry cooperative society officials should not take? Have you done that? They only say that they have not taken. But that's not taking it out there amounts to acting prejudicially to the interest of the cooperative society.
If your lordship permit, can I make one
Hmm.
statement? Either my friend has not read the writ petition or he is misleading this honorable court. Kindly see para 28 of my writ petition.
Para 28. Petitioner says the respondent number 6 bank had issued show cause notice to so and so an employee who has allegedly repeated in a said wrong has challenged the decision of initiation against him by way of a civil suit remand which is pending, and there is an order of injunction restraining bank from taking any action. Very interesting to note that respondent number 8, who is a shareholder who is also lodged the complaint against the petitioner, is an advocate by profession, and he is defending the case of when the respondent so also did not look into this aspect of the matter while passing the. Well, they've taken it, they just stay.
But the suit has been dismissed subsequently. They have filed an appeal, my lord. The one-man committee, my lord, they have come to an understanding with the employees association and they have come with some understanding with them, my lord. That is why instruction.
Chalo, we do one thing, we keep it on some other day. We'll pass an order after hearing both sides properly. As in view of Mr. Garodia's strong objections.
My lord, or otherwise, my lord, this can be disposed. The bank is, my lord, suffering.
Huh?
Because of, my lord, the bank is suffering, my lord.
Which bank?
The cooperative bank.
Cooperative, which one? I know, it has to be
City.
because it's a cooperative
The
society.
cooperative city bank, my lord. My lord, is
I have instructed that make it clear. The next step is one from the beginning. Because some others work. So at that regard, you will be granted by appoint some others.
It will Raki the Kali order did him. We'll pick it up tomorrow at 2.
Fine.
No. No. Mr. Das, do you have to say anything? What else? You submit, I'll pass the order only tomorrow. Today it's getting late for other matters. Tomorrow we are sitting, na?
Yes.
Monday too many matters. Tomorrow I have only 22 matters. Why do you want this matter to be kept parted? Not necessary. I don't keep parted very much. Yes, Mr. Das, what do you have to say out here? No, what do you have to say? You are appearing for whom? You see, the writ petition otherwise has become infructuous. So nothing remains. Only what he is saying that I will take care of and pass that particular order that this is not, that it shall not affect him in view of that paragraph at paragraph number 28. It shall not affect him under 37. That's over. Because of him, your thing becomes clear. But now I think tomorrow there won't be a stay order after 2. Don't remember. But let me pass the order. Ask your junior to be there. I'll just pass the order. No, tomorrow. Don't worry. If you have difficulty, I've heard you today. Matter has been heard at length about the matter only also heard at length. Let the matter be further taken up for passing appropriate orders tomorrow at 2. Yes, Minto.
I'm waiting for item number 52.
Yes, what is it? I am there till 5 o'clock. Don't worry. Mine, it's not finished.
So that way, your lordship, if I just may come up on 8.
What is that matter?
Land Graving Act, your lordship, under the land graving. Otherwise, the petition is not maintainable because it is to be.
Ask your junior to mention when the matter is. Because we are still continuing here. Na? Ask your junior to make a mention. Fantastic. Go to Nagaon and be out there with the mobile. Yes, I'll give you virtual. Go. Next. Yes,
This is a writ petition and the fact goes like that the father of the petitioner in the year 1998 demised. Thereafter, his name and his mother's name were mutated as inheritance. And in the year 2009, partition was done and some part was given to this petitioner. And thereafter, my lord, in the year 2017,
what happened to you? The mutation has been cancelled.
no. In the year 2017, private respondent filed a suit. Private respondents are the sister of the petition, married daughters of the original owner. And in the year
Who is
2017,
appearing for the private respondent? None is there. Okay, in view of the fact that the respondents, private respondents are not represented, list the matter again on 21st of August.
they have not filed any reply till date. Actually.
They won't.
It's
19.
public.
May I please, my lord?
Hmm.
My lord, the conducting council KB Pathak is out of station today, my lord.
Who?
KB Pathak, my lord.
Who is KP Pathak?
In Post of Pathak, my
What is this matter about?
matters pertaining to my lord, non-payment of professional dues to the petitioner, my lord.
NRC? Oh, you are there. Why you are not paying? The Pratik Hazela has been made a party or not? Why you have not made him a party? Pratik Hazela. They say that Pratik Hazela you have to claim from them. He did it from his own
There has
accord.
been claim in the affidavit, my lord.
Eh?
There has been claim in the affidavit, my lord.
Yeah.
Subsequently, my lord.
Okay. Don't worry, we'll have it some other day. As he is not there, because this is a case, one has to go to the civil court now.
My lord, a date may be
This-
fixed as your lordship.
What?
A date may be fixed, my lord.
No date. Is the matter, as the learned counsel appearing for the petitioner seeks for an accommodation, is the matter 2 weeks. Next.
My lord.
20.
May I please, your lordship.
What is the matter?
Lordship, land has been acquired, my lord, for construction of national highway, my lord.
Hmm.
So the private respondent and the petitioners, they are the brothers and sisters and the co-porters of the plot of land. Initially, my lord, the decision has been taken to pay the entire compensation amount to the,
Your amount has not been released.
my part of the amount has not been released.
Why?
But that is known to the, my lord, deputy commissioner.
National Highway, why haven't you made the National Highway a party?
My lord, here only, my lord, the thing is that, my lord, 50% they have released to the, my lord, deputy commissioner already released to the other side, my lord, the private respondents, and my 50% they are not releasing.
What is their stand in the affidavit?
My lord, they have not filed yet any affidavit. My lord.
Huh? They have filed, respond number 2 has filed. Why you are saying not filed?
Well, the copy has not been served to me, my lord.
They don't want to serve you a copy, maybe. It is admitted that the compensation has been approved in the name of 6 Patadars. What is your name? Faizul Hussain and Apur others. Your name is not there. Ansur Ali, Insan Ali, Farooq Ali. Oh. As per the report of so and so, it is seen that the man that area, the deponent accepted is admitted 50% has been released to the legal heirs of his fund. Rest of the 50 has not been, as the actual possession of could not be asserted in deliberation. And there is a dispute among the Patadars regarding the possession. You have not received the affidavit.
No, my lord, no copy.
Good stuff. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the state government has filed the affidavit without serving a copy of the affidavit. Who is Prosenjit Gogoi? AC of U.J. Soikia. Who is U.J. Soikia?
I am using this one.
Your AC, like an advocate clerk, is some Prosenjit Gogoi. You have a clerk, his name is Prosenjit Gogoi.
Dot.
So ask him. The learned counsel appearing on behalf of the petitioner submits that he have not been furnished the affidavit which was duly received by his advocate's clerk. And the learned counsel appearing on behalf of the petitioner submits that he would like to go through the affidavit so filed by the state respondents, by the respondent number 2 on 9th of June 2023. List the matter after 3 weeks.
22.
Yes, Mr. Kyle,
Hey, please, your lordship. Lordship,
what is this matter about?
This Sabka Vikas Lordship Legal Dispute Resolution Scheme, Lordship.
Hmm.
Lordship, we had applied for the scheme. Lordship, under the scheme, we have to apply under SVLDRS 1. So Form 1, we had filed SVLDRS. This was a scheme which had come to settle the dispute which has arisen, whatever disputes are there. So if we can pay some amount of money and thereafter the dispute will be settled. This was the scheme which had come. Lordship, the scheme is long over. It was over in the year 2019 itself. But what had happened in Lordship, the time limit for paying was till 30th of June 2020. The scheme Lordship got expired in the year December 2019. Lordship, thereafter what had happened, I had filed my SVLDRS 1, which was filed on time during the scheme, during when the scheme was in operation. Thereafter, Lordship, in the Lordship, when I filed the SVLDRS 1, in my SVLDRS 2, which they had to now issue, they have not taken note of some of the challans which I have already paid. I had made some payments. So even though they had approved it, but they did not Lordship, take in form the challans which I had already submitted. Lordship, my SVLDRS 2 is at page 51. So Lordship, that amount has not been taken into account. Lordship, thereafter I have raised my objection under 2A, but Lordship, thereafter without giving me any chance for explanation of the same, Lordship, they have rejected my Lordship application. So Lordship, I have Lordship challenged that rejection order before your Lordship, before this honorable court, stating that that challan should have been taken into account. I am ready to pay the amount, whatever scheme has offered me, but whatever I have already paid, that should have been taken into account. Now, Lordship, they have filed an affidavit saying that we did not know about the payment because you have not annexed the challan. Lordship, I have, by way of additional affidavit, annexed the challans also, that this amount was paid by me. So, Lordship, that should have been taken into account, and Lordship, this should have been paid. Now, Lordship, there is one contention on behalf of the Lordship respondents that now the scheme is long over. Why should the relief be given at this moment? Lordship, that is the main contention of the respondents. Lordship, there are judgments of this honorable court in Assam Cricket Association as well as in other cases, wherein this honorable court has asked us to apply again before the Lordship, before the authorities, and they have been asked to consider it again. And Lordship, this is not the only Lordship court wherein this type of cases has come. It has come pan-India level everywhere. Lordship, everywhere the similar type of cases had come. But Lordship, the apprehension of the Lordship, the respondents, which is there. No, give the spiral. Whatever the apprehension of the Lordship respondents is there, the same apprehension was put in other courts also. Ultimately, it went to Supreme Court also. Lordship, the Supreme Court, Lordship, may kindly see the fourth judgment, Staker Resorts Limited, which is at page 28. That since the scheme is longer, now why should we give relief? Lordship, there is no doubt that I should have been given the relief, but when the scheme is long over, why should be given the relief? Lordship, in Staker Resorts Limited, which earlier also I had given a compilation that is not on the record. I have given it a copy to the respondents also in this case. Lordship, the Supreme Court, Lordship, very recent judgment, Lordship 2023. Lordship,
page 29, Lordship, the issues which are before the Supreme Court, page 29, Lordship, paragraph 2.2. These are the two questions which has been put. The High Court should not issue a direction contrary to the scheme. The relief sought could not be granted as designated committee under the scheme is not existing anymore. Okay, thereafter, the Supreme Court has held that since Lordship, they had after that issued a Lordship circular that since all over India there is a Lordship, that circular I have annexed in the last page of the my compilation.
So they are now opposing on the ground that the scheme is long over
Yes, Your Lordship.
and the designated centers are not there.
Yes, Your Lordship.
And as such, no direction should be issued.
That is the Lordship. Lordship, in the last page of my compilation, I have annexed a Lordship, this is a notification by the central government itself, wherein they have said that because the
You filed your application within time.
my application was with.
Now, your only issue is that at that very point of time, these people were, means there were certain aspects which they have not taken into consideration. That needs to be taken into consideration. And what they're saying is, okay, we didn't look into this. But the fact is, the problem, however, is now we don't have that scheme and the designated centers are. That's it.
Lordship, the notification which they have issued, which was issued after the judgments all over India, Lordship, there were judgments which were given, wherein Lordship, they had allowed the people to file again before the.
You're saying about that 2021 circular.
Lordship, the circular. This circular, Lordship, they have allowed them to process manually. So, Lordship, the Supreme
And
Court.
the reference of this has been made at paragraph 8.2 of the judgment of the
Supreme
Supreme.
Court judgment, Lordship, the Supreme Court has said that since you are still allowing them to process manually, so why don't you, so it is not, you cannot make this type of submission at this moment and it should be allowed. Lordship, I had also filed my petition also on time, Lordship. In fact, some petitions which were filed after me have also been given, Lordship, due consideration. I have annexed all the judgments. Calcom Cement is there, Lordship, Newtech, other, Lordship, they have been given the favorable judgment is given, but Lordship, only my cases was left out. This case was left out. Lordship, my item number 13, Calcom Cement is there, 12 Urban Cements. All these judgments, I have annexed all the judgments.
So
But-
there also similar question arose.
Questions and they were filed after me. Similar questions, Lordship, almost all the cases are similar. They have been asked to file again and they have been, the authorities been asked to consider them and take payment, Lordship. Now this.
Now you want what?
Lordship,
That they should take into consideration that.
Lordship, I just want them to take my, whatever judgments have been passed, similar judgment may pass and Lordship.
No. In the other judgments, those people have been allowed to file.
File. I don't. know.
You don't want to file. You only want that they should take into consideration those claims as regards certain payments being made earlier
Yes, Your Lordship.
while taking into account whether you will come within the scheme or not.
I have Lordship withdrawn my appeal because I went to the SPLDR scheme. So my free deposit which I made, actually, it might be my mistake also because Lordship, what had happened, there was a free deposit which I had made. That is a 10% free deposit I have to make before filing of an appeal. Apart from that, I have made more payments. So I had taken the entire thing into free deposit account. Whether if they don't think it's free deposit, I don't know whether that is considered as free deposit or not because I have paid more than 10%. I paid this amount also. So that can be only mistake which
So
I
you want this particular amount, okay?
that may be.
Madam, we'll do one thing. We'll have a look at it on next Tuesday. And I'll just go through it. It's not so easy to pass in such manner.
Lordship, can it be?
Directed to Krishna.
Huh?
Yes, Your Lordship. Lordship, I had given a copy of compilation. I will give the copy of compilation. to you.
You give it to me.
Yes, Your Lordship. Lordship, can it be on Thursday?
Thursday?
Not. Wednesday, Thursday, Friday, any date, Lordship, after Tuesday. Any date.
Let the matter be listed on 10th.
Much love.
23.
Fair to also. My lord, as per the last order, my lord, the private respondent, my lord, who has, my lord, undertaken to pay, my lord, what was, my lord, wrongly, my lord, credited to their bank account, my lord. That is
Bank account,
bank account,
which account? SBI.
SBI.
Hello, where's the SBI? Not there.
In fact, that is run by one private respondent, my lord. The council appearing for this respondent, my lord, he has undertaken to make the payment because it is.
Okay, list the matter again on 14th of August 2023. Taking into account, none has appeared on behalf of the respondent number 5 and 6.
Deeply obliged.
24.
Wait, little lordship.
Oh,
So this is regarding the non-payment of grant in aid. Non-payment of grant in aid to the next of kin of the martyrs of the Assam Education, your lordship.
non-payment of
Grant in aid
for what?
for the to the next of kin of the martyrs of the Assam Education. There's a scheme of the government of Assam, your lordship.
Dated
Your lordship.
1511.
Yes, your lordship.
Huh?
Yes, your lordship.
Yes, where are these people? Yes. Under which scheme?
Annex of 40, Annex of 4, page 40, your lordship.
Annexure 4,
Page 40.
Martyrs of Assam movement. When did you apply?
In the year 2019, your lordship.
Hmm?
2019. The grant was declared in the year 2016, your lordship.
You were a part of the, yeah. You
Uh,
are who? Who
I
are
am
you?
the next of kin of the martyr, your lordship. The nephew of the martyr, your lordship. On the earlier occasion, his brother was receiving. But on his death, now the next of kin is the nephew of the martyr, your lordship. It was duly verified by the competent authority.
I have the honor to furnish you with the details of so and so. So your name of the deceased so and so. So this has been done. This
Lordship.
has been sent to the joint secretary. Now the joint secretary thereupon what has done? He has written to the president
He has written
to
to the
request you to
president.
make a verification in concern with the ex gratia grant of so and so to Samsul of nephew. How's the nephew gets?
Lordship,
He has no son.
no, he was unmarried. He was unmarried, lordship.
Then if somebody is unmarried, then he becomes next of kin.
No, lordship, the martyr was unmarried, your lordship.
Understood. So the nephew becomes
The next of kin, the next legal heir was his elder brother. That is the father of the petitioner.
he is not alive.
No, he is not alive, lordship.
So that means you get it.
Lordship.
No. This is something very serious.
No, lordship.
Mr.
Because
Borua and madam, you should oppose tooth and nail about this thing. How is it possible? Then tomorrow, if we give it to this, why not some grandchildren of somebody? How is it? He's not the next of kin. You can't have a next of kin in this manner. Is it something like the legal representative? Are you going as per the Succession Act? Somebody will get. That can't be the idea to the effect. That must have been this next of kin means that you file an affidavit. This is not done. How will you do it? The government is.
He has served any extra copy for it.
Petitioner has not served, but this is serious. You serve a copy out there. Mr. S. Borua and Miss P. Mohanto appearing, the learned counsel appearing on behalf of the revenue, I think you should file.
27.
Miss P. Mohanto appearing on behalf of the revenue department should is directed to file an affidavit. No, the revenue department is directed to file an affidavit as to whether a nephew of an unmarried martyr can be considered as a next of kin for grant of ex gratia grant ex gratia grant of rupees 5 lakhs in terms with the scheme dated
Your Lordship, it was declared in the
because
10/12/2016. Your Lordship.
huh?
10/12/2016, the government has declared.
10/12/2016. List the matter again on 28th of August 2023. Ms. P. Mohanta, appearing on behalf of the Revenue Department, submits that the said affidavit shall be filed in that regard. List the list the matter on so and so. The registry shall also indicate, show the name of Ms. P. Mohanto appearing on behalf of the revenue.
25.
No, this is something very serious. If you don't do it here, all matters this will happen. If you are considering a nephew to be a next of kin, Hari? Government. Yes.
May I please, Your Lordship?
Ah.
Lordship, by this writ petition, the petitioner is paying for a direction to the respondent authority to demarcate a plot of land in the village of Kaljar and the revenue circle, Boroma, in the district of Baksa, my lord.
That's Mr. N. Goswami appearing on behalf of the Deputy Commissioner. Baksa
Baksa.
shall obtain instruction as to why who is going to demarcate? The Deputy Commissioner. You get your instructions only to that effect. Shall obtain instruction as to why the request made by the petitioner seeking demarcation. Oh no, this is by to the revenue circle officer. You don't represent. Who is appearing for this one? Baksa, BTC, nobody. Taking into account, you are appearing? Taking into account that none has appeared on behalf of the BTC. So list the matter after 2 weeks.
26 to 29.
Yes, what matters are these?
It's regarding.
Victim compensation.
Yes.
Huh?
Yes, my lord.
Why? Nobody is paying you? What is your instruction? Is entitled, not entitled? This is only one.
Two.
These are 2-6, this one. The reference I would like to say that I have no fund has been, the new fund has been received as on today under the victim company required. So fund is to be given by whom? Revenue,
Government.
home and political.
Government.
Home and political victim compensation 357. This is 357A.
357A.
All these matters.
Yes, my lord.
Okay,
lordship
consider except this one, it said this is admitted. Otherwise, others will be considered and make payment 6 months. 6 months or so. Yes. All this.
And your lordship.
You are there?
Yes. I am.
Okay, give your names.
My lord, your lordship has disposed of a case directing the government, my lord, day after tomorrow, yesterday, my lord. WC 2784 directed Commissioner and Secretary Home to release the fund.
That is what, in
Yes.
that man, that Anwara Begum, that matter, I will direct the Commissioner and Secretary Home and Political
Yes.
to release the amount to
Yes.
you so that you can pay.
Yes, no.
30.
You have that order?
My lord, not yet online, my lord. Your lordship has passed the order.
Okay,
Not
I
yet.
passed so many orders, I forget. Yes, tell me. 30. Yes, tell me. Vet. Where is the vet council?
Lordship, on 3/5/2021, Lordship.
Dead stock.
As per audited 3/5/2021, Lordship, we have
You are filing affidavit.
You have to file affidavit. Have to check. Thereafter, which is the pilot of purchases, money I could borrow.
Huh?
Some demand, money, purchases, but I have to credit borrow.
Neither am I. Okay. This is all excise.
Yes.
So, okay, Mr. D. Gogo appearing on behalf of the excise department seeks for an accommodation for how much? Accommodation for 2 weeks for filing the affidavit. List the matter again on 11th of September 2023. Let the affidavit be filed by 28th of September, August. The petitioner, if so advised, would be at liberty to file their reply by 7th of September. List accordingly. Interim order passed earlier stands extended till then.
All right.
Because you file it, and that is why I pick for final disposal.
31.
The similar prayer, Lordship.
Same man.
Same matter, same matter. Apply.
Thirty-two.
Yes.
Yes, your lordship. In fact, this case is covered by your lordship's judgment,
Which one?
Northeast High Tech Lordship versus Union of India.
Hmm?
Northeast High Tech versus Union of India.
Oh, that matter.
Yes, your lordship. Lordship, what
That was on the particular facts of the case.
yes, your lordship.
How is it applicable here?
Lordship, I'll lordship argue on that point. Lordship, in this case, lordship, we had filed a special writ applications before the respondent authorities. After the judgment of the Supreme Court, lordship. The Supreme Court judgment in VVF Limited, lordship, regarding the central excise cases. Lordship, the central excise cases, lordship, earlier we won the case before the single bench. Thereafter, lordship, the matter went into division bench. The division bench also, lordship, have held the case in favor of the lordship petitioner. And lordship, the notifications which were impugned in the lordship were set aside. 2008, 31, 2008 and 32, 2008, all the 3 notifications were set aside, lordship. Thereafter, lordship, the matter went to Supreme Court. Lordship, the Supreme Court in VVF Limited versus Union of India have said that the notifications which were
No, no, madam, I remember.
Yes,
Don't
sir.
worry.
Yes, your lordship.
I have delivered the judgment. I don't forget.
Yes, your lordship.
Your thing is that you wanted to submit that thing within that period. That period must have been over. You
Yes,
couldn't
sir.
file it and as such.
Yes, your lordship.
So it is on that facts I have stated. Now you have to say that these facts also apply.
Yes, your lordship. Not
Whose?
yet disclosed of.
Yeah. That application was rejected.
Rejected. Lordship, in spite of lordship, instead of lordship, my special writ application has not been disposed of, but they have issued a demand cum recovery notice, lordship. Without lordship, if they don't lordship, what is my actual demand, if they don't come into the final this one, lordship, then lordship, impugned demand cum recovery notice cannot be issued. Lordship, in fact, in this case also, lordship, I have prepared a compilation. There are several.
Mr. Kyle, are you filing affidavit or not? Or not necessary? Because now that day as I was taking up that matter now, what is that matter? Where you raised the maintainability point and I rejected it. No, that matter pertaining to the bond,
Yes, sir.
bottler. Bottling of this thing. See, if I am to entertain this petition, it has to be on a question of law. Meaning thereby the facts has to be taken as if the facts which have been stated in the impugned order to be correct. If there is a dispute, I am not going to take it up. Now, on the basis thereof, if a law is shown that applying the same facts in view of this particular law, then he has a right, obviously he has a right, he will get it. But if he doesn't, matter ends there. Hello, we'll take it up when?
As you also previous. After Tuesday, any date law.
Huh?
Any date after Tuesday law.
Or you have
Okay.
issued raised the issue of maintainability. This is the matter again on 22nd August for final disposal. No, for final disposal. The interim order passed earlier shall continue.
Lordship, the 32, 33 and 50 also same.
15 or 50 already
That date will be decided.
99,
But the matter is similar. They are saying that in that case, they have already given me special rate.
There is the order.
That-
Last locator is the number for directly to supply for the order by.
But nothing survived.
Lordship, on 22nd, all the three matters may be taken up
Why
together.
they are for last 14 years?
Lordship,
Item
in
50
case,
to
in
some.
case, Lordship, we will see.
No, if there is nothing out there, why not? Why
Lordship,
should
will-
we keep it? If you are asking for exemption,
They may challenge that order or if they are not satisfied.
No, Lordship, Lordship, I will just say, I'll just produce a copy of the order that after the special ed applications have been, Lordship, considered. There is an order passed by this honorable court by which the court has given a liberty. Because we have not just challenged that special ed application, we have said that the interest is also not applicable in this case. So the court had said that
hello.
liberty has been given, Lordship.
Okay, 22nd.
22nd, Lordship. Lordship, tomorrow also there is a case, Lordship, I'll not be there, my juniors will be there, that will also be fixed along with that.
That we'll see tomorrow. I have only 22 items. I have fixed another 2. So if I can get a chance, I may dispose of, then you may say that the repetition has become inflexible.
Much obliged.
34.
Yes.
My lord, in this case, my lord,
Affidavit file. What is the matter about?
my lord, the father of the petitioner, my lord, purchased annual patta land in the year 1971, and since then they are enjoying. My lord, petitioners are the brother, my lord. They are enjoying the land, my lord. And what happened in the year 2017 by a non-renewal case, my lord, that has been cancelled and reverted to khas land, my lord. Thereafter, my lord,
What did they do?
land.
You were enjoying annual patta.
Annual patta land that is purchased from the annual patta there, my lord.
Okay.
And that is enjoying, my lord, since 1971. In the meantime, my father died and the present petitioners are enjoying, my lord. In the year 2017, my lord, that annual patta has been cancelled due to transfer to the father.
Was cancelled.
Cancelled, my lord, by a non-renewal case, my lord, by deputy
Okay,
commissioner.
then
And it is reverted to, my lord, khas land. Thereafter, my lord, petitioners applied. by
khas land means it has to be government land.
government.
Why are you saying khas land? Anyways, government land. Then
And thereafter, my lord, petitioners applied for, my lord, settlement of that particular land, my lord,
Hmm.
by Buddha Prada. And circle officer, my lord, recommended for settlement, my lord. But subdivisional land advisory committee, my lord, rejected on the basis of a prayer made by the Jilla Parishad, my lord, who have already, my lord, given 2 acres of land in the adjacent land, my lord, for their office to additional area. And that application has been filed, my lord, subsequent to us, my lord. And on the basis of that, our application has been rejected. And thereafter, my lord, we have approached this honorable court and the status quo has been, my lord, directed to be maintained, my lord. And the government, my lord, now filed their affidavit. And my lord submitted that, my lord, they have made alternate accommodation of another plot of land, my lord.
to give it to you.
Yes, my lord, that is their proposal, my lord. But what happened, as per my instruction, that land is also, my lord, occupied by some other person since long back, my lord. If that is going to be accommodated as, my lord, then there may be some, my lord, situation of law and order, my lord.
Oh, you have been allotted the land.
That was not, my lord, actually officially communicated to us, but we have instructed our, my lord, the client after getting this affidavit, my lord. And then they come to know, my lord, that particular land which is going to be allotted by government, my lord, that is already occupied by some other persons, my lord, since long back, my lord.
So
So, my lord, now, my lord, on the
you
last,
want some other land.
no, my lord,
You want that land where you are.
maybe, my lord, but if the government can, my lord. take it
Mr.
the-
Counsel, first of all, you are asking for a settlement.
My-
The settlement will be made by the government as per their own desire as to which land is to be given or not.
My- admit-
Now, if they say that this is the affidavit, we have given a settlement, if you have any problem, you may file an affidavit stating whatever you feel like,
Right.
stating that there is somebody else in possession or so and so. Or you may approach the authority concerned that, look here, that this is the land where give me the possession of it. Or for whatever may be. But otherwise, what other things remain out there? You are asking for settlement and the settlement has already been given. I keep the matter alive. Go and approach the authorities. We'll keep it after 4 weeks. So not 4 weeks. We'll have it after the autumn vacation, puja vacations. Interim order shall continue. In the meantime, do whatever you feel like. Go and search out. Place the matter again on footstep, taking into account the affidavit so filed by the
Respondent number 2, my lord.
respondent number 2, wherein it has been mentioned that there is wherein it has been mentioned that the petitioner has been allotted a plot of land measuring 2 bighas, 2 kathas, covered by Dag number 114, Dag number 75 and 114 of village Paihata under Nokari Moja. Wide an allotment proposal dated 5/1/2021. List the matter again on 6th of November 2023. Full stop. In the meantime, the liberty is given to the petitioner to approach the deputy commissioner. Which one? Deputy Commissioner Lakhimpur, seeking possession as well as demarcation, seeking demarcation and possession of the said land so allotted. Upon payment of there will be a payment of premium, na? And approach the Deputy Commissioner Lakhimpur for the purpose of completion of the formalities required pursuant to the allotment so made. Full stop. The interim order passed earlier shall continue till date.
35 and 36.
In the meantime, I think something can be worked out. Yes.
My lord, there is the order dated 21/7, my lord. This honorable court directed the standing council PWD, my lord, to receive instruction. Take this that, my lord, the petitioner is a contractor, my lord, is a contract some work under
What is the matter about?
non-payment of contractor bill, my lord.
Hello, we'll have it after 2 weeks. We'll have it on 16th of August. This is the matter on 16th of August. 38. Yes, Mr. Sheikh.
My lord, by an order passed by your lordship in WPC number 6770 of 2021,
Oh,
that order dated 24/6/2022.
where?
It is regarding this MSCT, my lord, which was decided in Loka Adalat.
Ah.
So 1,50,000 was settled.
Hmm.
Now what happened, my lord, a later we found in the record that the insurance company deposited a check. Deposited a check of rupees 1,50,000.
Ah.
And it was directed by your lordship that on proper verification, the amount may be disbursed.
Hmm.
But till date, my lord, That is not disbursed. We approach the registry also.
Where? Yeah,
Here, my lord.
the registry has not disbursed it.
Not disbursed, my lord. And your lordship would be pleased to see, no, nothing has been noted.
Why you are
regarding
not,
the order
have you
dated
filed
to
the application before the registry?
My lord. Yes, my lord. That
Where is that
application
application?
is there, my lord.
Where?
24/6/2022 order, my lord.
Page.
And we filed application on 5/9/2022
Where?
in the registry, my lord.
Where is that application?
That application is in record, my lord.
Where is that? Oh, to the registry.
Yes, ma'am.
Then?
One thing is this, my lord, a check is deposited.
Hmm.
Thereafter, my lord, registry has not done anything.
But Mr. Sheikh, why haven't, if registry has not done, shouldn't you have filed a miscase out there in that case? Or why haven't you made the registry a party if the insurance has not done anything wrong?
Your lordship would be pleased to see the order dated 24/6/2022. It is clearly said the written communication
To release the
produced by
amount
Mr.
after
Datta
due
to be
verification.
retained in the record. In
Understood.
view of the above, registry to release the amount after due verification. It is a clear order from your lordship.
Full stop. List the matter again on 14th of August 2023. On which date? The Registrar General of the Guwahati High Court. On which date? The registry of this court shall submit a report in pursuance to the order passed by this court on 24/6/2022.
Oblige, lordship.
62.
Oblige.
Oh, yes. Therefore, adjournment has been made by you. Yes, what is it? Huh? Slaughterhouse. Slaughterhouse of goat. They are closing it down, GMC. They have closed it. And they have got a stay. Having regard to the so-and-so and going to submit a report dated so-and-so, they'll submit a report. The order dated so-and-so be kept on record, huh? And the hearing number. Okay. None appears on behalf of the petitioner as well as the GMC when the matter is called. In that view of the matter, list the matter again on 28th of August 2023. Is there an interim order? No.
I know 40 and 41 orders.
Yes,
May I please, my lord? My lord, this contempt is filed,
complied.
not complied.
Why not? Huh? Oh, 40. These are 2014 contempt matters. If there is not being complied, it is a serious matter. What is this matter order?
Page 12 is the first order, my lord. There are two orders. my lord.
Page 12.
Order dated 28/5/2014, my lord. There is one referee.
In the interim, since the referee educator course is scheduled to commence on so-and-so, the Assam Football Association is directed to immediately forward the petitioner's application to the All India Football Federation for necessary action. Then,
Page 15, my lord.
Respondents must, however, make sure that the report to immediately transmit the petitioners. But Mr. R. Day so and so for a submits that the petition is defective for be that as it may, since an interim order was passed, the respondent number 4 is required to comply with the order. They should accordingly forward. Now, what happened to the petition? Have you forwarded it? No, then nothing remains.
Page, Lordship, may kindly see page 17.
Yes,
17. My lord, I have reported, my lord.
yes, then
My lord, it is in the bottom part, my lord. 5/6.
reported on so and so and returned back as we have not received from
No
Assam Fair in support of his eligibility. Okay, then
Then, my lord, they have filed the affidavit, my lord.
what do they say? Page 22. 22. Yeah, evaluation of the potential among the retired so and so. This is a reference to the subject. I would like to inform you that we have received an application from for the above course from Deepak Kumar, but he did not fulfill the criteria laid down by the Assam so and so on the above course. We are unable to forward his application and kept it pending till he fulfill the elevate. The criteria is given. We accordingly submitted new case before the High Court and passed an interim order with our mark. We have received the certified copy and we are forwarding his application with the following remark that he should not be allowed to take part in the course for the following reasons. He's still an active referee, being so and so, so and then when was it received? Yes. Uh,
Last week.
uh,
Email was also sent on 6th.
huh?
Email was sent.
Where?
Last week.
Page?
7.
Page 27 is not an email.
Technology.
This is to acknowledge that your letter dated received by the undersigned by email on so and so. So then this has happened. And when did this thing happen? When his sign was there?
5/6.
17th of
So it was received. If this is received, then what remains?
My lord, if Lordship may kindly come to page 17, my lord. It says, my lord, received without any documents.
Understood. This is reported on 5th
Yes, my lord.
and returned. He says that it has been done in this returned back as we have received no document from so and so in support of his eligibility.
Yes.
Yes, you were not eligible, but what did the court order? Court ordered you this to be forwarded.
Yes.
They forwarded it
My lord,
and said that he's not eligible.
my lord. My lord, in this case, what happened, my lord? The first order was passed on 28/5. Then thereafter they have filed one IA, my lord. Then next order was passed on 2/6. my lord.
But they, in that order, the court only said that as you have passed an order, you forward it.
Yes, and to make sure that this.
But
received
did
in
not
time.
say that you are to declare, that they are to declare you to be eligible.
No, my lord, that is not there, but they have, my lord, intentionally, my lord, on 2/6 order was passed. On 3/6 evening, they have sent. And my lord, one is by email and the one is through the courier, my lord. And by the email, they have not sent any document, my lord. Only when the courier is sent, my lord, all the documents are in Excel. That's why, my lord, this applicant was not allowed to participate in the training, my lord. My lord, it says, my lord, that documents, only email
But
is,
Mr. Counsel, kindly see page 24 of his affidavit.
yes, my lord.
We have received the certified copy of the Honorable High Court's order today on so and so, and we are forwarding his application with the following remark
Yes.
that he should not be allowed to take part in the course for the following reasons. So and so is still active, so and so, and so and so.
Yes.
So there, this has been specifically mentioned.
Yes, because
Well-
of the my lord, they have raised the objection with regard to eligibility, my lord. So the court has directed that whatever it may be, you forward the application.
this has
whatever
been
the remarks,
forwarded.
my lord. But my lord, they have not forwarded my documents, my lord. Because if Lordship may kindly see page 17, my lord, it is said that they have not received any document, my lord. Only email is sent, my lord, but no document, my lord. My lord, had the document been sent, my lord, then this petitioner is allowed to participate in the training, my lord. And my lord, this is done intentionally, my lord.
But Mr. Gupta, what remains in this matter further?
My lord, this person, due to this act of the, my lord, opposite party, he has, thereafter, my lord, since he was age barred, my lord, he is not able to go for the referee post, my lord. And my lord, due to this act,
Now, what has happened to your writ petition?
writ petition is still pending, my lord.
Huh?
It's still pending, my lord. Otherwise, my lord, because the prayer.
So you want to now, the only remedy left is to punish him for non-compliance of an interim order.
That is it.
Taking into account that the matter would require detailed hearing, list the matter. Oh, this writ petition is here.
Yes, ma'am. Right, sir.
Detailed hearing. List the matter again on 24th of August 2023. On which date an attempt shall be made to dispose of both the writ petition as well as the contempt proceedings.
All right.
Service complete, list the matter for admission.
45.
No, has been received. No. 44 actually.
44.
আগৰ কোনকেইটা? 42, 43 হৈ গ'ল। 44.
44.
44 হ'ল, এক মিনিট দেই। 44 হ'ল লেনে চেনে মালাকিয়া। Okay. Okay, so as the service is not complete, 44 to as the service is not complete, the petitioner is directed to take fresh steps upon the respondent, sole respondent.
45.
List the matter again on after 3 weeks.
46.
Here, my lord, respondent number 4, the DC has been transferred, my lord. I may be allotted some time to make.
Huh?
Respondent number 4, that is DC.
You have 46, na?
My lord.
Respondent number 4 died.
No, my lord, DC has been transferred. Yes, respondent number 4 is DC that has been transferred. So I may be allotted some time to implement.
The petitioner seeks for an accommodation to implead, to take appropriate steps for impleading the new,
Deputy Commissioner,
the present income deputy commissioner of
Kasar,
Kachar. So list the matter after 6 weeks.
Macho,
You have to issue a notice.
Macho.
47.
May I please, lord?
Hmm.
Contempt is filed against the interim order of the writ petition. But writ petition has already disposed of on 26/7/2023, Lord.
Hmm.
So Lordship, please the matter the closed. Please the matter may be closed.
So nothing remains.
Yes.
Item number?
47.
47.
The learned counsel appearing on behalf of the petitioner submits that that in view of the orders passed in the writ petition, huh?
Yes, Lord.
Nothing survives. Writ petition being WPC number
WPC number 994.
994 oblique
2022. Lord.
2022.
Yes.
Nothing further survives in the present contempt proceedings for which the contempt proceedings Full stop. Taking into account the said submission, the instant contempt proceeding stands closed.
48.
Wait for it.
Hmm.
Complete the order.
Orders complied with. Show me that. 48. What is the order passed?
31 feet. The order was passed for in charge. For saying the order is
Where is the order?
page 10
Of?
of the contempt petition.
Accordingly, the respondent number 4 not having the qualification actually cannot remain as the vice president of the government. In that view, himself will be a private satisfaction of also partially sustained. Accordingly, as the process has begun giving charge to the president of the Popa to the respondent is stayed until further order. So this is the order.
This is the order.
Then
But this is my page 5 of it. Running page
5.
next to 1.
Compliance to the directions passed in, I have issued an order dated when by the state that the earlier order dated instructing the charge of the to the state till for the orders with immediately. Then the post of president. The instant contempt proceeding was initiated on account of on the allegation of willful disobedience of the order dated 31/8/2020 passed by this court in WPC number 3291/2020. It reveals from record that on 6/1/2021, the Deputy Commissioner Hosai Shankar Devnagar had passed an order in compliance with the order dated 31/8/2020. Thereby entrusting Srimati Alsuma Begum, Vice President of Daboka Gaon Panchayat, to look after the works of the President of Daboka Gaon Panchayat.
So, that order is clear. Now that goes to the
This is the order you have enclosed.
6-1 says first. The
Oh,
order
okay. Where passed an order dated 6/1/2021, whereby the order, whereby the post of the President of Daboka Gaon Panchayat was directed to remain vacant. So, taking into account the above, this court is of the opinion that the order dated 31/8/2020 passed in WPC number 3291/2020 has been complied with, and as such, the instant contempt proceedings stands dropped.
49.
Yes.
Your Honor, in this matter, we filed the IA and the opposite party filed the objection, written objection. Kindly fix a date for final hearing.
You data
Final hearing. Final hearing.
for what? What is the amendment sought for? In a writ petition. You are challenging sale deeds in writ petition. Huh? You want to put locks in the civil court? Huh, tell me. Huh? What will happen to those judges, the lawyers?
My lord, in this matter, the original land has been allotted by Johat Development Authority.
Understood, it's a sale deed.
Thereafter also my lord, implication granted, separate matter has been set.
Hello, we do want this 49, na?
Yes.
Okay. We'll have it some other day. List the matter again on 30th of August 2023.
Highly obliged.
51 and 52.
51 and 52. Yes, Mr. Sharma, haven't seen you for a long time. Tell me.
My apologies, my lord.
and court. And now my lord, has arrived. That my lord, court is referred.
No, may I just submit?
See, it's not so easy with Mr. Sharma. He'll come with something.
My
Yes.
lord, there are total 33 cases between the husband and the wife. So recently they had a mutual understanding that the husband is gonna drop the other cases which are lying. However, meanwhile, there was a 226-2 writ petition that was in filed, and the court has granted an interim order. Our service upon respondent number 2 has not been completed. So my lord, let that service be complete.
Who is respondent number 2?
State of Punjab. State of Punjab.
Why?
My lord, because his NI cases were filed in Jalandhar.
You are challenging those.
Yes, we were challenging the jurisdiction of the case, and that's why 226-2 we lied. An interim order was granted to us by staying those cases. However, thereafter, a matrimonial case that was been going on, that was been settled, where there has been a submission. And true fact, my lord, that the respondent here has stated that we will take away those cases. But as of now, nothing has been communicated to us.
Okay, you file it by way of an affidavit. I won't take it. Okay, you bring it on record. It's an order. Bring it on record. Miss So and so appearing on behalf of the respondent number 4 and 5 submits that there has been some amicable settlement amongst the petitioner and
Respondent number
respondent number 5.
yes, ma'am. 4.
Respondent number 4. Pustak. Taking into account the above, she submits that the said amicable settlement has been duly recorded in an order passed by the family court. It is the opinion of this court that the said be brought on record by filing an affidavit. List the matter again on 28th of August 2023.
My lord, let us complete our steps on respondent number 2 by then, because they will be able to give the proper status about whether the case has been withdrawn or not. So that is why let the steps be complete by us.
Have you done it?
Yes, my lord, actually this matter had come up in Lawsim. My counsel friend here submitted that it has been settled. And that's why on 131.
Mr. Sharma,
Yes,
I have fixed it on 28th. You have done a lot of time. You want to take fresh steps.
I'll take fresh steps. So my lord may direct.
Mr. SP Sharma appearing on behalf of the respondent number, on behalf of the petitioner. Petitioner.
Yes.
Further submits that he would like to take fresh steps upon
Respondent number 2.
respondent number 2 in WBC number
5424 of 2021.
5426.
5424.
5424 oblique 2021. Pusto. He is given the liberty to do so.
My lord, the interim order passed earlier.
Interim order passed earlier shall continue till the next.
Also,
53. You're gonna 53. 17th of August. Okay, I think what item number 50 objection has been filed on behalf of Iman. Okay, list the matter again on 17, not possible. On 30th of August, 30.
55.
You want to file a affidavit? When? You have taken earlier also. You are saying that Karimganj district, it is therefore not possible. How much time have you taken for filing the affidavit? Tell me. This is a repetition of 2017. You have not filed affidavit. We asked that, who is that? Karimganj, DC?
Yes.
Huh?
Yes.
We asked him to be personally present.
No, my
That
lord.
is the best way out. No, no, no. Where nothing doing, no 4 weeks. Just taking into account that the matter pertains to the year 2017. Standing it. The Learned Council appearing on behalf of ASIDC. Or which one? ASIDC. ASIDC submits that he requires 4 weeks' time for filing the affidavit in opposition. Full stop. Taking into account that the writ petition is of the year 2017. This court fixes the matter on 21st of August 2023. The affidavit be filed by 17th of August 2023.
Interim order may be.
Huh?
There's an interim order.
Interim order passed earlier shall continue till then.
56.
On the earlier occasion.
Why haven't you filed appeal? You know I don't like to review my order.
Lordship,
Go and file appeal.
Lordship. Otherwise, Lordship, there are similar incumbents who are working there.
Huh?
Lordship. There are similar incumbents who are working there.
You bring their list also. You brought it.
No,
You have not brought that. Then you are saying your point out there is on the basis that the taxation department, this amendment was not made applicable. It had to be made applicable. That is your case. Very well, no problem with that. But show me some other persons out there who have been done so that I can take their recourse also. Remove them.
Let them bring it on record, Lordship.
Why? You
No,
were,
Lordship,
they are not there
that-
today.
That they are not, that they are following the amended rules, Lordship. The earlier occasion, Lordship,
Okay.
we were,
Did I ask for filing the affidavit? Notice I have issued, na?
no, Lordship had asked it to file their affidavit, Lordship, on 7/6/2023, Lordship had asked.
Them to file affidavit.
Yes, Lordship.
Affidavit has been filed.
No,
This court by the order dated 7/6/2023 had directed the Finance and Taxation Department of the Government of Assam to file the affidavit. However, no affidavit has been filed. List the matter again on 4th on 23rd of August, no, on 11th of September 2023. The affidavit be filed by the Finance and Taxation Department without fail by 7th of September 2023. You inform the other side, huh?
Lord.
Sure.
obliged, Lord.
57.
My lord, the petitioners filed this petition for restoration of the writ petition, which have dismissed for non-prosecution, my lord, on 3rd of January, my lord.
No.
The order is at least 10, my lord.
Then
I could not appear, my lord, on that day.
Yes.
My lord, on that day, I could not repay, my lord. Because of that, the matter has been dismissed, my lord.
Do you have a case?
Yes, my lord.
What case?
My lord, as per order, referred to a division bench judgment, my lord. But that,
Your basic case is there was this 5 lakhs was given, you wanted it 10 lakhs. Isn't it the case to be done before the acquisition authorities?
My lord, in my case, no any notice has been issued, nor my lord, negotiation has been made out with petitioner, my lord.
So your land has been taken?
Yes, my lord.
Then why haven't you not approached the authority for the purpose of enhancement of your compensation?
Uh,
That is the case, you should have done it. What is all these things you are? I don't understand what is wrong with the lawyers out here. It is clear.
And
Section 18 is clear if it is the old act. Section 64 is clear as per the new act. If you go by the National Highways Act, it is section 3G, it is clear. Then I don't understand why the lawyers out there are encouraging filing of the writ petitions in this manner.
my lord, oil has taken my land, my lord, but not following the procedure of law, my lord. Because, my lord, they
Have
to
they gone
follow-
for an acquisition proceedings?
No, my lord.
How did you take the land? By
That is the-
purchasing?
That is the case.
No. How did you take the land? No. How did you take the land? Right of? Rule 1? Land law of what law? No, other patadas may do whatever may be, but how can you take a land? We have, I think, for oil also, the registration and the transfer of property act applies. Well, so, your name,
MC.
Kansu. This is an application for, I restore it. We'll hear the matter. Huh? You understood. Let the matter be alive, then becomes, he may get more money. Yes. This is an application filed for restoring the writ petition which was dismissed for default by an order dated 3/1/2023 by this court. From a perusal of the application, it transpires that it was on account of the fault of the counsel who was not present in the court for which the writ petition was dismissed for default. Taking into account that it was absolutely the fault of the counsel and not the parties, this court is of the opinion that the interest of justice demands that the writ petition be restored. Accordingly, the writ petition is restored, thereby full stop. In the IA, the writ petition is restored, thereby restored. Full stop. Interlocutory application stands disposed of. And writ petition list the matter again on 22nd of August 2023 for final disposal.
Pleasure, Lord.
We appear on that day.
Yes.
to 61.
Yes, madam, what are these matters?
Lordship, in 58 item petitioner died, Lordship. So we have filed one IA for substitution. Lordship.
What is these matters about?
Lordship, our land is a purchased land, registered sale deed, Lordship. So when we are paying revenues, Lordship, subsequently we came to know that the land were converted to government khas land, Lordship, without giving any notice.
Okay. And when these people died?
Lordship, he died on 19/7/2011, Lordship. But they were not aware, so
19,
7/2011.
who died?
No, Lordship, 19/7. Death certificate I have enclosed, Lordship.
Petitioner.
Yes, Lordship.
And you filed this petition on
No,
behalf of dead persons?
No, Lordship. 27/2/2022.
Okay, that is it.
Yes.
The
Lordship.
date, all.
Petitioner died on 27/2/2022. Legal heirs, para 4, Lordship.
In all the cases,
No,
same.
only 58, Lordship.
Huh?
Others are connected matters,
Oh,
Lordship.
others are connected.
Yes,
ঠিক আছে, এখন allow করে দিব। In the order to listen.
IA 1997. Lordship.
I dispose.
Apply.
Yes. Okay, 29th of August. Ago to, huh? 29th. We'll dispose it of. Because you see, you can't take of this land in this manner.
The part, I put a big part. And actually empty or put with, thereafter they are not. So I take the other.
If you, the execution of the sale, if they don't do, you can't help it. You can't force them. The deputy commissioner has no business of this.